Is lecture started? Unconfident बोलायचं आपल्याला कॅमेरा. हॅलो हॅलो हॅलो.
Hello, yes, sir. Good morning, sir. Good morning, sir.
केसकर मॅडम.
Yeah, we can hear you.
Okay. Okay. Now you made me host. Hello. Hello. बस बेटा शेअर स्क्रीन करायचंय का? हॅलो केसकर मॅडम. हॅलो. शेअर स्क्रीन सुरू झाली का? त्यांना एवढं दिसेल मागच्या पण.
बर्थडे हाँ क्या
Switch off करा please. Vinod, please mute yourself.
विनोद सर तुमचं माईक बंद करा.
Please switch off your mic, please. Please put your mics on mute mode. Pawan sir, can we start?
Yes.
Hello, Vasanta ma'am.
Very good morning.
Good
Yes.
morning, ma'am. How are you?
Sorry, I got a bit late because I had lectures in the class. Please start.
No problem, ma'am. No problem. We were waiting for you only. Yeah, 2
Okay,
minutes, ma'am.
okay. Right.
Yes, ma'am.
Yeah, we'll start. We'll start. Boita madam.
Yes, ma'am.
Akshay sir.
Ma'am. Yes, ma'am. I'll start now.
Yeah. Akshay sir. Huh.
Yeah. Okay. Yeah. Yeah. A very good morning to all of you. I, Assistant Professor Akshay Ugle of Modern Law College, Pune, heartily welcome all of you to the one-day international webinar on emerging trends of fundamental rights, comparative constitutional perspective in association with Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka. Uh, I welcome you all once again, and now without wasting much of your time, I would request our principal, Dr. Sunita Adhav ma'am, to deliver the welcome address for the webinar. Over to you, ma'am.
Thank you so much, Ogle sir. Very good to all of you. It gives me inform you that Progress College and it is an association with Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka. We are organizing this international webinar on emerging trends of fundamental rights, a comparative constitutional perspective. I, Dr. Sunita Ada, Principal of Modern Law College, welcome all the dignitaries, researchers, PhD scholars, academicians, and students for this international webinar. In short, I just would like to tell you about Progressive Education Society and also about the Modern Law College. Progressive Education Society is a reputed and it is a distinguished educational institute in Maharashtra. It was founded by Sri late Shankarrao Kanetkar along with his team of 5 teachers. He had laid the foundation of the society and it was on the auspicious day of Akshaya Tritiya on 16th of May 1934 in Pune. Progressive Education Society has been making a noteworthy progress for last 87 years. This educational institute is young of 87 years old and it was started with a noble path and principles. Professor Dr. Gajana Nigbote is presently holding the office of Chairman, Business Council of Progressive Education Society, Pune 5. In order to keep pace with the changing scenario of education, he has introduced emerging and the need-based courses in the institutions run by Progressive Education Society. It is an account of his It is on account of his proactive approach and foresightedness that he has successfully been leading 62 different units of Progressive Education Society, which are under the umbrella of Peace Society. The two remarkable words that appears in the name of the society and educational institutions are progressive and modern. The inclusion of these two words was certainly with some noble intentions, which serves as a right beacon for Progressive Education Society to be followed with determination, and they are really values for all of us. Progressive is nothing but keeping with the spirit of time and innovation, while modern is nothing but modern in outlook as well as up to date in all the matters, whether it is in the sports or in the academic matters. or even in cultural activities. Now, shortly about Modern Law College. Progressive Education Society's Modern Law College, Pune 16, which is one of the premier legal institute in Maharashtra. This law college was established in the year 2003, and it has really carved a place for itself. This college is permanently affiliated to Savitribai Phule Pune University. It is also recognized by Bar Council of India, and it is also recognized under Section 2F and 12B of UGC Act of 1956. This college is also accredited by NAC Bangalore with a CGPA of 2.84. This college stands one of the best law college in Pune. All the courses of the college are approved by Savitribai Phule, which includes 3-year course, 5-year DLLB course, Masters in Law, and also diplomas and certificate courses. And shortly, we'll also start with our own PhD research center. The academic excellence of the college is manifested from the results of the students, not only in academics, but also in sports and curricular activities. Students of the college have really made us proud on various events. The students has won laurels for the Peace Society's Modern Law College also accommodates several foreign students also from countries like Iran, Sri Lanka, Afghanistan, Thailand, South Africa, etc. And college also pays special attention for the development of these students. Every year, college organizes national as well as international seminar and certain workshops. This year, due to pandemic situation, we are organizing a national webinar on constitutional perspective. And this international webinar, it is in collaboration with the Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka. Just briefly about what is this Department of Public and International Law, Faculty of Law, University of Colombo. This is one of the youngest department in University of Colombo. This started functioning in December 2009, and this is currently in charge of offering special subjects at an undergraduate and postgraduate level. The expertise of the teachers at the department is very much in line with the demand of today's academic and need of the society. Faculty of Law, University of Colombo has made a unique contribution to Sri Lankan legal community. University of Colombo is Sri Lanka's university and has made a proud tradition of academic and research excellence. This university is unique and it draws a rich history that mixes the leadership in arts, science, management, finance, education, law, medicine, and graduate studies through various fields. We show our gratefulness to this Department of Public and International Law for accepting our invitation for collaboration for this international webinar. Just in short about the theme of the webinar, it is comparing the constitutional perspective of fundamental rights all across the globe. Because constitution of every nation is a supreme law of land which upholds the rights and the duties of the individual. The aim of having declaration of fundamental rights in the constitution is just to prevent the possible dangers due to state action against the violations of fundamental rights. Recognition of fundamental rights under the constitution provides a restraint on the powers of government to interfere with the people's right arbitrarily. When the rights and freedoms are placed in the constitution, they become a part of supreme law. Fundamental rights are included in the constitution because they are considered as a very essential for development of individual. And the need for having the comparative method has become inevitable to study the existence of fundamental rights. In current times, when the society is fast changing, we see judiciary also is playing an important role in development and protection of the rights and duties which are enshrined under the public law document. I again welcome all the aspirants for this international webinar, and I hope at the end of this webinar, we have some concrete thoughts in our mind. From bottom of my heart, I welcome all of you for this international webinar on behalf of Modern Law College, and I in person welcome all of you once again for this webinar, international webinar. Thank you, Akshay sir.
Thanks a lot, ma'am. Thanks a lot for your wonderful welcome address. Now I would like to introduce the first resource person for today's webinar, Associate Professor Avinash Kole, sir. Sir was an associate professor of political science at Ruparil College, Mumbai, and retired in the year 2017. Before joining academics, Sir held various responsibilities for some top advertising agencies and serviced leading brands. Sir is also an author as well as a book reviewer, and also Sir does translation of books from English to Marathi. Sir has translated the biography of Dr. Manmohan Singh from English to Marathi. At present, he is pursuing his PhD from University of Mumbai on separatist tendencies among the Muslims of Xinjiang province of China. His novel Chaukat Watoli, published in the year 2018, has won the prestigious Baba Padamanaji Award for the best novel of the year. The award is instituted by the Yashwantrao Tate Memorial Institute, Wardha, Maharashtra. Also, I would like to add here that Sir did come for a guest lecture to our college even before this lecture, and hence I would like to welcome you, sir, once again to the college. And this time, instead of your physical presence, we are having you in form of an webinar. So thanks a lot for being a part of this, sir. And over to you, sir, now.
Hello. Hello.
Sir, we can hear you, sir.
Okay. Thank you, madam. Good morning.
Thank
This is Avinash Kole from Mumbai. As has been told to you, my presentation would be on the constitutional changes in China with regards to minority. Because in the world of fundamental rights, today, we are more concerned with the fundamental rights of the minorities in any country. Asia has always been home to many minorities, but Europe was always a nation state with conventional ideas of one language, one culture, one religion, one state. Monochromatic perception of nation state. But post 1991, and thanks to globalization, we see tremendous movement of labor, technology, capital from A country to B country, A continent to B continent, etc. As a result, even Europe today has to deal with a new issue called minority rights. This is precisely why you have riots in Paris, you have countries banning new mosques coming up. What I'm going to drive home with the illustrations is the fact that today, in 21st century, as we have entered second decade, minority rights has become a burning issue across the countries, more so in Asia and Europe today, where we include China as well. With this, let me take you into the story of my presentation. It is interesting to note that two big countries of Asia, that India and China, two leading civilizations, have started their journey as a modern nation state almost simultaneously. India attained freedom in 1947, whereas Marxist revolution succeeded in China in 1949. So there is just 2 years difference between these two countries stepping into the modern world with different political systems. China is a Marxist country with one party rule, whereas India is a liberal democracy with multi-party system. These are the some basic differences between the two, but they share a lot of similarities with each other. It is necessary to understand the profile of India that we propose to discuss. Since time immemorial, China has always been a multi-ethnic, multi-religious, multilingual country. As a result, it has to deal with minority in modern world. Before beginning of 20th century, all over the world, in many cases, there were monarchies where monarch did not have to worry about minority rights. But come democracy, come republican form of government, and each and every person voice counts. This is why in modern world, minority rights has become an important factor. So China has to be studied in two phases: pre-revolution, that is 49 Marxist revolution, and post-revolution. If you look at pre-revolution China, the concept of minorities entered Chinese discourse during 1920s onwards, that too was influenced by Marxist-Leninist ideal on nationalities. As a result, a new word was coined, Minzu, which means minority. It was not there in Chinese vocabulary in 19th century and before. In 1911, as we know, Dr. Sun Yat-sen overthrew imperialism in China and set up Republic of China. Yet there was some confusion about what is minority and how to deal with them. As a modern political leader, Dr. Sen was quite aware of the fact that in modern world, a country has to deal with minorities. According to him, then China had five basic minorities. Han, five basic, not minorities, sorry, five nationalities: Han, Mongol, Turkey, Manchu, and Tibetan. Yet he expected that in due course of the time, they will all merge into become a Republic of China, Grand China, where their differences among various nationalities will be submerged into a big China. That was his expectation in 1911 when he had successfully led Republican Revolution in China. During the same pre-revolution China, we also witness the birth of CPC, that's Communist Party of China, 1921. So this July, 4 months from now, 5-6 months from now, CPC shall be celebrating its centenary year. It will be a 100-year-old party come July 2021. As it was progressing and there was a civil war between CPC and nationalist forces in China, the border areas, according to CPC, it announced that Mongolia, Tibet, Chinese Turkestan, that we call Xinjiang today, would be autonomous states or banned in Chinese vocabulary when communist revolution succeeds in China. So even Communist Party, let's say, had accepted the fact that a modern state shall have minorities, and Communist Party of China, CPC, had identified three major areas, geographical areas, Mongolia, Tibet, and Chinese Turkestan, as Xinjiang was known then, to be autonomous states in People's Republic of China, which they had set up in 1949. Now, from pre-revolution China, let's shift our attention to post-revolution China. In 1949 October, China officially became PRC, that is People's Republic of China. 1911, it was Republic of China. Few decades later, under Mao's leadership, Republic China became People's Republic of China, official communist country. But once he came to power, by entering himself into the seat of power, he forgot about all the promises that he had made to various minorities in China. And not only that, Tibet, which was promised autonomy in 30s, was occupied. Then other minority areas were similarly forced to integrate into China, PRC, People's Republic of China. Now, to understand this modern China, we must look at its various features of the profile. First is China is a multilingual country. There are 55 official minorities in China. 55. And they belong to various language families. Like Hui, Manchu are users of Chinese language, that is Mandarin, whereas other 53 minorities speak their own languages. 29 minorities have languages belonging to Chinese Tibetan language family. 19 minorities use language that belong to Altic language family. 3 minority groups use language which are which are from the family of languages in South Asia, and 2 minorities speak Indo-European languages. So even in China, from outside, we perceive it to be a monolithic country, but in reality, it's a diverse country which is with mind-blowing diversity. First, we are focusing on language, and we are noting here that there are 55 minority nationalities speaking their own different languages. Like India, China too is a multi-religious country. There is a Lamaism, a sect of Buddhism, follows in the Tibetan, Mongolians, Uyghurs. Then there is Hinayan, which is known as lesser vehicle, another sect of Buddhism, has believers among nationalities as Bai, Das, Degan, Achan, Blanc, Dingpo, and some of the Ras. Even Islam is being practiced by Hu, Uyghur, Kazakh, Tatar, Kyrgyz, Tajik, Uzbek, Tongzin, Salar, and Dona. Some part of Chinese population also practice Protestant sect of Christianity. So look at this, and you find that from outside, again, we find that China is a uni-religious country. These details should convince you otherwise, as they tell you that there are practically all important religions of the world available in China. Multi-ethnic China. Like India, China too is a multi-ethnic country. The first census in PRC, People's Republic of China, was held in 1954, that is 5 years after Marxist revolution succeeded. That 54 census registered 39 ethnic groups which are labeled as national minorities. A decade later, in 64, second national census took place, where the number of national minorities jumped from 39 to 54. And then came census of 1979, which noted 56 minorities. So today, China has 56 minorities in the country, which we find quite mind-blowing. Now, part 2 of the same piece of information, look at population dispersion. which is the single largest group, contribute 92% of the total population of China. Which means in China, 8% population belong to minorities, which are further subdivided into various groups of minorities. But broadly, what we need to keep in mind that almost 10% of Chinese population are not Han population. They are non-Han population. Like India has 80% Hindu, 20% non-Hindu. Now within non-Hindus, we have Muslim, Christian, Buddhist, Sikh, etc. Similarly in China, almost 90% are Han and 10% are non-Han. Now those 10% non-Han are further divided into two categories. A group of people with population more than 10 million and group of people with population less than 10 million. So in the first group, there is more than 10 million. We have Zhuang, 18 million, Uyghur, 11.5 million, Hu, 10 million, Manchu, 10 million. Then there is a third group, which is known as minority population, where population is less than 1 million, 10 million. Neo, 9 million, Yi, 7.8 million, Tujia, 8 million, Mongol, 5.8, Blue, 3 million, Yao, 2.3, Koreans, 2.5 million. So this is the ethnic group wide population of China that together add to 8% of the total population. Now, this is precisely why Communist Party of China had to decide on ethnic policy. How do you get this mind-blowing figure of 55, 56 minorities in the country? That took place in 1949, for which the CPC organized People's Political Consultative Conference, where the ethnic issues discussed thoroughly. This conference was attended by Mongols, Hui, Tibetans, Uyghur, Miao, Yi, Manchu, Korean, Bei, Li, and Uzbek. Almost all important nationalities had attended the conference that took place in Beijing in 1949, just during the foundation of People's Republic of China. The conference, People's Political Consultative Conference, decided that all nationalities within the boundary of PRC shall enjoy equality, which means whether your population is 5 million or your population is 10 million, it does not matter in the eyes of the state. All nationalities within the boundary of PRC, Public Republic of China, shall enjoy equal rights, equal protection from the state. Next important point, in 1949, the Chinese leaders were fully aware of the fact that there can be a clash between greater nationalism, which means Han nationalism, versus local nationalism, which is minority nationalism. And both should be opposed because both will pose obstacles in the path of creating a greater China, a united China. And there shall be no discrimination, no oppression of any minority as was guaranteed by the state. As we know, all fundamental rights are guaranteed by the state. In fact, there are claims against the state. This is all we know as a students of law. So I'm not taking the debate into that basic level. I take few things for granted that as a student of law, as a teacher of law, as a scholar of law, you have this basic understanding of fundamental rights. I'm building my theme on the basis of that foundation. Now, 1949, Mao was the tallest leader. So as a result, we need to understand the changes that took place in China under Mao's regime. Then we'll visit Deng's regime, and finally we will come to Xi Jinping's regime. So let's begin with Mao's China. As I told you, 1949 conference took place. It stipulated that regional autonomy, please understand, regional autonomy, a region in China is going to enjoy autonomy, but it should be exercised in the areas where national minorities are concentrated. So it's not that all regions will enjoy autonomy. Those regions where national minorities are concentrated, they will have more autonomy than other provinces, regions of the China. So you must identify in map of China those areas where national minorities are concentrated, which means their minority become majority, and majority becomes minority. All ethnic minorities were granted freedom to develop their own language, spoken and written. As we know, today each and everybody person, country is deeply touchy, concerned about their language and their religion. We all know how Bangladesh broke away from Pakistan simply because Bangladesh speaking Bengali did not get the same status in Urdu speaking West Pakistan, the then West Pakistan. As a result, finally, the Bangla speaking East Pakistanis felt alienated and broke away from parent country. What I am trying to hint at is the importance of language in a society's life and its future. Hence, Chinese authorities had promised all ethnic minorities that they will have a right to practice their spoken language as well as written language. What Indian Constitution also guarantees its citizens. Article 29, Article 30, right to linguistic minorities. Then these minorities will also enjoy freedom to preserve and reform their traditions, customs, and religious belief. Which means state will not interfere. This is 1949. Just with the birth of China, the authorities felt it necessary that minorities should be given assurances, protection, and encouragement at state level so that they feel happy, settle in the modern China, which is going to take into account the aspirations, problems, hesitations of minority groups. And last point, people's government, that is PRC, shall assist, help all national minorities to develop politically, economically, culturally, educationally. This is what we call state intervention. This is what we call state's role in socio-economic educational field. That state shall not only look after the interests of majority Han, the national minorities, the 55 that I talked about, will also get state support for political development, for economic development, for cultural and educational development as well. Which means for state, whether you are Han or whether you are a Uyghur or whether you are a Tibetan or whether you are a Mongol, just does not matter. You are Chinese first, you are Chinese last. This is theoretical position. What actually happens in practice is a separate story. But we must understand how Chinese structure was erected post-revolution. Autonomous regions. As we look at the map of China, we find that Han population is in minority in some regions, and non-Han nationalities are majority in some regions. As a result, with this awareness, the reality of life, the Communist Party of China, few years before, it became successful in establishing Marxist revolution in October 49. But 2.5 years before that, in May 47, it established Inner Mongolia Autonomous Region. Which means even then, 2.5 years before, they could control the entire China. The CPC leadership announced that Inner Mongolia, will have autonomy, more autonomy than the other provinces of China. So this autonomy debate actually started in China much before PRC was born on 1st October 1949. So this is known as the earliest and largest autonomous region in China. That was in 47. Now from 47 to 85, China has 5 autonomous regions, means 5 autonomous provinces, and there are 31 autonomous prefectures and 96 autonomous counties. This is like a state within a state. We have in India, in Northeast, some districts of Nagaland have more autonomy than other districts of Nagaland. So this, a modern country has to ensure that within democratic framework, majority should not dominate minority. The word minority assumes importance in modern political discourse simply because we accept that majority does not mean the rule of more people or rule of or less people. It's not domination of 51% on 49%. Though 51% have come to power, that does not mean they can ride roughshod over 49%. When 49% will also enjoy special minority rights. This is about that issue where officially there are 5 provinces. One of them is Xinjiang that I am going to talk about. There is Tibet, there is Mongolia. All these are separate uh, states. When I mention state, I don't mean nation state, but like Maharashtra state, Karnataka state, Assam state. So, or other parallel word I propose to use is province. They call it autonomous regions. So 5 regions. Then within balanced regions, there are 31 autonomous prefectures. So almost like districts, and 96 autonomous counties, which is almost like our tehsil. So China is not uniform from A point to B point. There are various geographical changes, the differences that has is part of the modern China. Like India adopted its constitution after it became independent. We became independent August 47, and our constitution promulgated on 26 January 1950, which means for 2.5 years we are putting our constitution together. And similarly, in China, first constitution was promulgated in 1954, that is 5 years after communist revolution succeeded in China. Hence it is known as Constitution of 1954. Now it is interesting to know why it needed a constitution and how was it functioning from 49 to 54. As I told you initially, there was civil war between nationalist China and CPC, known as Kuomintang, led by Chiang Kai-shek. In 49, when revolution almost succeeded, Communist Party announced common program, which was almost like constitution, but not the constitution in a formal sense. So from 49 to 54, the common program that was announced by PRC was used as provisional constitution. And since it was provisional, since many things were yet to be finalized, it had no allowed provisions for minorities. So from 49 to 54 is one unique phase in the history of modern China where it had no official adopted constitution, as India had no constitution from 47 August to 26 January 1950. Now let's look at this constitution of 54, which became the first constitution for modern China. It came into being on 20 September 1954. We had a preamble, we had 4 chapters, we had 106 articles, and officially China became a communist China. Officially, PRC was proclaimed on 20 September 1954 as India was proclaimed Sovereign Democratic Republic of India on 26 January 1950. That's our legal identity. Then, Sovereign Democratic Republic of India, 26 January 1950. Then in 1976, 42nd Amendment added 2 more words, socialist and secular. So now India's identity is Sovereign, Socialist, Secular, Democratic Republic of India. That's a separate story, but since it's running parallel to our main thing, I thought let me add. So PRC became a legal entity on 20 September 1954, and as Indian Constitution guaranteed equality to all citizens, irrespective of caste, creed, color, language, gender. Similarly, Chinese Constitution also guarantees equality to all citizens, whether you are a Han, whether you are a Uyghur, whether you are a Hui, whether you are a Mongol, whether you are a Tibetan. That does not matter to Chinese state. In social life, you may say I am a Tibetan, somebody may say I am a Mongol, but for Chinese state, you are a Chinese person, Chinese citizen. Like for Indian state, you and I are Indian citizens. Whether I am Marathi speaking, you are Bengali speaking, whether I am Hindu, you are Muslim, just does not matter to Indian state. And as we promise those citizens that state shall not have discrimination, oppression on the basis of language, religion, caste, creed, gender. In similar manner, Chinese constitution also promises its citizens that there shall be no racial discrimination. And as we guarantee minority rights, similarly, Chinese Constitution 1954 also guarantees protection of customs and beliefs of minorities. Now, since we are on the Constitution and the fundamental rights, we must understand the unique features of Chinese Constitution 1954. This was as our Constitution was under the influence of Government of India Act 1935. So was Chinese Constitution, which was under the heavy influence of Soviet Constitution 1936. And what does that mean? It means Stalinistic thinking shaping Chinese perspective on minorities. And what did Stalin think? Minorities are a nation made up of people with common language, historical culture, and territory. So you share the same language, you share the same historical baggage, and you share the same territory. That makes you a minority. That gives you a status of a nation. That has to be incorporated in the grand design of the country. That was Stalinistic thinking of early 30s, which also influenced Chinese perspective on minority. As a result, autonomy for ethnic minorities became central issue in the discussion. In fact, I am quoting here draft Article 70, which should be read very carefully. As we all know, it's a legal language, legalized. The political organs of the autonomous self-governing regions shall exercise their autonomy as prescribed by the Constitution and by the law. In simple language, like India, China, Constitution is supreme. And everything has to be within the framework given by Constitution of China. This article explicitly says that whatever the autonomous self-governing regions want to exercise, they must ensure that their unique features fit into the main Chinese concept. Minority leaders were with this arrangement. They felt that they will exercising their autonomy as prescribed by the Constitution or the law means it is shallow protection to their autonomy, their ethnic rights. Because what is allowed and what is not allowed will be decided by the law. So they have to adjust their culture, language, religion, way of life, which leaders fit that. Hello. So many minority leaders were not very comfortable with this 54 constitution as they felt that this constitution has diluted the minority rights. Non-Chinese leaders disagreed. So there is a debate between minority leaders and majority leaders represented by Han community. They felt that rights like right to an independent budget, to set up public security force, to make local laws are more than enough to ensure your autonomy, to ensure your way of life, and to ensure your ethnic identity. It did not be, there cannot be anything more than that. So the debate is how much autonomy can a minority enjoy in a country dominated by majority. Han, that is 80, almost 90% of the population. The Chinese leader, Han leader, further said that it is dangerous I repeat, dangerous, to grant ethnic minority unlimited self-governing rights. Limited self-governing rights, accepted. Unlimited, unaccepted. They would, because the next logical step would be, they would soon ask for unreasonable rights like right to secede and right to become part of other country. Which means which means in other words, you accept the right to break the country, break the union, and move out of the country or become part of the another country. Which means take the Uyghur, Xinjiang. Now it can become part of Russia, it can become part of many Islamic countries that it borders. So that right is not allowed. A minority region will not have right to break away from the People's Republic of China. So these are two diametrically opposite positions. Minority leaders demanding large amount of autonomy, majority leaders accepting the idea of autonomy but not accepting the idea of so much autonomy that it ends up breaking the country. So finally, a balance was struck and country moved ahead. Now, these are all of theoretical discussion, Constitutional Assembly debate, but what happened actually? During Mao, two things were launched, Greatly Forward, which lasted for about 4 years, and Cultural Revolution, which lasted for about a decade, 66, 76. During these two important events, minority rights were trampled upon. There were no minority rights in real life. They are on paper, but they are not to be enjoyed by the majority. Mosques were burned, prayers were banned. If you are wearing a Islamic cap, the cap would be removed. If you are greeting people with Islamic salute, Salam Alaikum, even that was banned. So all that minority rights, which were promised by 54 Constitution, were trampled upon. Soon after, that is 4 years after Constitution was adopted in 54, Great Leap Forward was launched. A decade later, Cultural Revolution was launched, and in both the cases, who suffered most? Minorities. Where is minority? First Constitution, when Mao was at the peak of his career, he realized that the 54th Constitution gives more rights to minorities than necessary. Hence, he was trying to rewrite the Constitution, and it did in 1975. It was adopted on 17 January 75. A year later, Mao died. But the most important part, see, normally in any modern country, there is a political party with its own constitution, and there is a constitution of the country. So BJP has its own constitution, Congress has its own constitution, Shiv Sena has its own constitution, and there is a constitution of India. Mao attempted to integrate both. So I am the state and state is me. The party is the state is the party. There is no distinction between the political party and official state structure. There was Chinese, there was Mao idea at the end of his career, which wanted to integrate CPC, Communist Party of China's constitution, with country's constitution, so that automatically minority rights will be shrunk to almost negligible level. Look at this. Article 2. CPC was the leading force of China. So, Communist Party of China gets the leading role in Chinese society. Article 4 says, PRC is a unitary multinational state and unitary, no federalism. Like UK is a unitary country, China will be a unitary country, will multinational states, and areas where regional autonomy is granted are enabled parts of PRC, which means no question of breaking out of the union, no question of seceding from the country, and all nationalities, but all nationalities are equal. This again is a theoretical offer to all Chinese people in 1975 Constitution also. What was in their 49-54 was also repeated here, that big nationality chauvinism. Similarly, local national chauvinism must be opposed, as Han nationalism will not be encouraged. Similarly, Tibetan nationalism will not be encouraged. Uyghur nationalism will also not be encouraged. Mongol nationalism will also not be encouraged. That is the idea behind putting this third point in the 75 constitution, which can also be known called as Mao's constitution. But like 54, this constitution also allowed nationalities to use their own language for speaking and for writing. Spoken language, written language. 28, Article 28. Citizens enjoy freedom of speech, praise, assembly, association, procession, demonstration, and most important, right to strike. Very important, interesting point. In 75, Mao's constitution allows working class right to strike, which is quite interesting and a bit shocking too, because it's a workers' country, a country run by workers, which means workers are owners. In such situation, there is a need for strike. But this constitution allowed right to strike. Now, how much of these rights are used by people in real life is a big question that we'll set aside for some time. Last point, this is important because China, like USSR, then like Cuba today, are atheist country. And when I say atheist country, secular country, that does not mean they are like USA, India, UK. Their secularism is anti-religion. State will take a anti-religion position officially. Here, Chinese communism departs from Soviet communism and allows people right to freedom of religion. They may believe, they may not believe. They may worship, they may not worship. That is nothing to do with the state business. That is the idea behind last point. Enjoy freedom of to believe in religion, freedom not to believe in religion, and propagate atheism. Now, life of this constitution was only 3 years, and this is till today. This is supposed to be one of the shortest lived constitution in the history of modern India. 75, and in 3 years later, it was new constitution. New means I don't say completely new. It's an amended constitution, reformed, refined. Deng era began after Mao's death. Mao died in 76. Deng era began in 78. Between those 2 years, 76, 75, 76, 77, 78, they are known as years of confusion, years of chaos, because old order was going away and new order was yet to take place. So these are the confusing years, chaotic years, in which slowly, steadily, Deng consolidated his position and control over the Communist Party as well as People's Republic of China. Hence, under Deng's direction, 78 Constitution was put together and was adopted on 5th March 1978. One of the most important features of this 78 Constitution was to remove all negative elements introduced by Mao's Constitution 1975. As a student of Indian Constitution, we all know that Mrs. Indira Gandhi drastically changed Indian Constitution thanks to 42nd Amendment 1976 during emergency era. She was defeated in March 1977 elections. Janata Party came to power, and in Janata Party piloted 44th Amendment 1978, which undid almost all bad things that Indira Gandhi introduced by 42nd Amendment 1976. Matlab, the new constitution of India, as was born out of 42nd Amendment, lasted for 2 years. And in 78, 44th Amendment undid all the bad things introduced by 42nd Amendment in 76. Similarly, in China, bad things which were introduced in 1975 by Mao's constitution were undid by Deng's constitution 1978. Look at the last point. Many checks and balances which were present in 54th constitution were restored. 75th constitution introduced features which would make dictatorship of a person soon. I am not talking of dictatorship of party, which is a part of the Marxist elements, principles that a communist country will always be ruled by Labour Party, Communist Party, and they are called dictatorship of the proletariat. Now, in China, Mao attempted to ensure that his rule lasts as long as it can, and nobody should be able to question him. That's why the normal checks and balances put on the office of head of the country were removed by him in 75, which were restored by Deng's constitution 1978. Hence, we call this beginning of Deng era, which also meant new economic policy. In India, it was done in 1991 by late Narsimha Rao and Finance Minister Dr. Manmohan Singh. New economic policy was launched in China by Deng, in India by Narsimha Rao. And there's a difference of gap of nearly 10, 15 years, 78, 91, 13 years. This constitution was necessary. Dengism became necessary as it is admitted today that Communist Party as a party, as an instrument of governance, was losing its face. Despite promises from 49 to 49, 59, 69, 79, almost 30 years, the PRC was not able to remove poverty. It was not able to fill stomachs of Chinese people. So they were losing legitimacy. And this was due to the rampant poverty in China's countryside. Deng realized that this must be removed by state intervention as well as giving people more freedom and autonomy to minority areas. This was to ensure that the new economic policy succeeds. Then came more comprehensive constitution 1982 under Deng's direction, adopted on 4th December 82. This is the official beginning of Deng era. It removed all bad things that were introduced under Cultural Revolution, and now China was ready to move ahead as modern nation state. As we are talking about minority rights, under which religious rights become important, let's look at how 1982 constitution was quite different from all earlier modern Chinese constitution. As I noted, for 10 years, 66, 76, minorities in China were persecuted by the state. 82 constitution gave citizens right to believe in any religion as well as right not to believe in religion. State organization, public organization, individual should not be compelled to believe or not to believe in any religion. Means you are free to believe in God, you are free not to believe in God. Government will not force you this way or that way either. It's your decision. You believe in God, fine. You don't believe in God, fine with the state. At the same time, what was given in 54 was also reiterated by 82 constitution that no state discrimination on the caste, creed, color, gender, that normal minority features. Important point. State shall protect normal religious practices. Like Indian state protects normal religious practices, Chinese state also protects normal religious practices. Like there is a public procession of Ganpati or Dandiya. Government will ensure that untoward incidents don't take place by deploying police force to ensure that law and order is not disturbed. There is a state responsibility to protect normal religious activities. But at the same time, state can also stop a religious activity which is disrupting public order, impeding health of the citizen, interfering in the education system of the state. So, on one hand, though state will protect religious activities, on the other hand, state will not protect those activities, religious activities that are bar to create, that are hurdles in the path of creating a modern secular country. Last point, this is what gets debated in India often. What is the foreign funding to these bodies? religious bodies are not subject to any foreign domination, means either through one or either through ideology. Let's take the discussion further. The idea in 1988, amendments were made to Chinese constitution adopted in 82. These amendments were adopted on 12th April 1988, and the amended article say the state permits private sector of the economy to exist and develop within the limits of prescribed by law. Now, in 88, Deng realized that state resources are not infinite. They cannot do everything that society needs. Hence, private sector should also be encouraged to invest in those sectors where state will not be investing. So what we call in economics joint mixed economy is what was introduced in China by Deng in 1988. But that amendment did not disturb any minority rights, but unlike Mao, Deng did not believe that minorities are a pain. They are responsible member of the country is what Dengism stands on. Then another amendment took place 5 years later, 88-93, March. Here again, more privatization was allowed, but nothing but discussion took place about minority rights. Then another amendment took place in 1999, where Article 28 was revised to read the state order and suppresses treasonable and other criminal activities that endanger state security. This was in light of terrorism dominating the global community, and now China also realized that sooner or later it will also be attacked by terrorism, and hence it has armed itself with more power to ensure that treasonable activities shall be suppressed. Means any anti-terrorist activities, we have Bopota, we have Tara. That's a Chinese version of that. Another amendment took place in 2004, that is 21st century. Article 33 was revised to read state respects and preserves human rights, because by this time China had become infamous in violating human rights of the community, human rights of the citizen. As a result, this was the one charge that was always thrown at Chinese state, and they were defensive about defending their how do I say, dishonorable record on human rights. And also, this is in the shadow of 9/11/2001 Act attack on USA. Now, final era, shipping era, we came to Deng era. Now we are coming to a discussion with shipping. There is some noise coming from somewhere. Please switch off your mic. Yeah. In Deng era also did not introduce new constitution. Like we have 75 constitution, we have 4 constitution. In fact, shipping made drastic changes in 2018. Just 10 days from now, it is the 3rd anniversary of that, 11th March 2018. Article 45, it cancelled the upper limit of 2 terms for the President and Vice President of People's Republic of China. Before 2018, President of China, a person can become President of China twice. A person can become Vice President of China twice. There was the upper limit. Xi Jinping repealed it and said any number of terms will be allowed. Now, Article 47, it granted cities, it grants cities divided into districts to the power to make local regulation, which reads as follows. Jump onto the second slide. Bit longish, but something in law. People's Congresses of cities divided into districts and the standing committee may adopt local regulations in accordance with provisions of law, provided that they do not contravene the constitution, law, and rules regulation and the local regulation of the corresponding provinces or autonomous region. Simply means you can have a local rules, regulation, but they should not contravene the national constitution, national law, and they should not be create a tussle between local law, local practices versus national practices. Next, they shall take effect after being reported to and approved by the standing committee of the People's Congresses of the corresponding provinces. Supposing Bombay Municipal Corporation or Nagpur Municipal Corporation wants to make some changes, it must refer those changes to national government before implementing them, which means you must get ratification of your proposal by the national government. Now, let's look at some interesting point. Despite so many provisions for minority protection and development, some regions of China, Tibet, Mongolia, Xinjiang, have minority majority tensions. You have Tibet, Burma, Mongolia, Xinjiang, all these provinces of China, which are border provinces, have been witnessing separatist tendencies and minority majority tussle. It is observed by many scholars that these pro-minority provisions given in Chinese constitution are more on paper, but in reality, not much is given to minorities. In fact, in these parts of China, minorities lead a very pathetic life. We know Dalai Lama, Tibetan leader, we know Uyghur problem. These are the two regular problems which often get discussed in a international platform about China. Now, in 21st century, Chinese premier has launched BRI, Belt and Road Initiative, a very ambitious program to revive old land Silk Route as well as old sea Silk Route. Now this land Silk Route goes through Xinjiang, which is a volatile province, but Chinese leadership is suppressing all the activities under the anti-national activities, under the banner of anti-national activities. Slowly, the special benefits, special concessions granted to Chinese minorities are being withdrawn. And the most controversial was done in 2015. Non-Han population in China is exempt from one-child policy. Han citizens must have one child. Non-Han citizens of China were allowed to have more than one child because they should not feel that they are outnumbered and outpowered in the system. But this provision was withdrawn in 2015, which has angered minorities in China a lot. Now, looking at this at a macro level, I want to submit these two positions. How does one govern minorities? This is a new challenge before many multi-ethnic states. And how does one, as I told you, the reality of 19th century Europe, one language, one country, one religion, one country, one culture, one country, all that monochromatic perspective is completely out of vogue now. And almost all major countries today are have population of more than one religion, more than two languages. Look at Canada. There is a Quebec province, French speaking. Other three provinces of Canada, English speaking. The Quebec province has been asking for separating from Canada. There have been referendum, and I think the last one that was held in Quebec reported 45% people wanting to break France and become a separate country. Just another 6% more, and the map of Canada as we know today may not be there 10 years from now, 20 years from now. So separatism, where more than two language people stay together, or separatism, where more than two race people stay together, are inherent in the situation. So how do we manage this situation? How does one govern minorities? Do we give them special rights programs? This idea is accepted all over the world. As I told you, in China has minority protection. India has minority protection. Almost all major countries have minority protection, and yet the minorities in those countries feel persecuted. The real issue is how much is too much. Means how much rights a minority should enjoy in a majority dominated country. The majority will feel the minorities are enjoying more than required. Minorities feel they are enjoying less than required. So the question is, how much is too much? Is 10 rights more or 10 rights rate? Is 20 rights appropriate or 25 rights are needed? There is no easy answer to this solution. This tricky problem. World will have to learn to live with this. But what is the conclusion that we can derive from this discussion? Beyond the point, no majority, whether it's Han in China or any other domination, can dominate minorities anywhere. Minorities have to get special rights to protect their distinct identity, that is language, religion, culture, way of life, marriages, etc. And these rights should be real rights and not written only on paper. Just to give an example, in China, there is reverse racism, where Han, majority Han, are treated as same as racism in those regions where minorities are majorities. Now, this is again on paper. Because if this was the reality, then China today would not have been witnessing ethnic tensions in provinces like Xinjiang, Tibet, Mongolia, and now add to that Hong Kong. With that, I close my discussion. Thanks a lot.
Good morning to all.
Yeah,
I would
Manu,
like to thank.
just one second.
Good morning.
Yeah.
Okay. You want to say something, sir?
ये इकडे कुठे विचार नको स्क्रीन दाखवायचं आहे मला स्क्रीन दाखव स्क्रीन मला दिसते ना सगळे Now I can see all. Please go ahead.
Good morning to all. I would like to thank and express my gratitude to retired Associate Professor and Nobelist Mr. Avinash Kolle sir for enlightening us on the constitutional changes in China with regards to minorities. Sir, your speech was very much effective and informative, and you presented your views in a systematic and clear way, making it easy for us to understand the evolution of these changes. We look forward to have your guidance and support in future as well. Thank you very much, sir.
Yeah.
Now we will proceed with our next technical session. It is very well said that anyone can be a moral individual concerned with human rights problems, but only a college professor or a technical expert can solve the problems by sophisticated methods. It is my privilege to introduce and welcome our honors research person of this international webinar, Professor Vasanta Seneviratne Madam, who is the head of the Department of Public and International Law, Faculty of Law in University of Colombo, Sri Lanka. Madam is highly qualified and has a vast experience of almost 25 years of teaching, research activities in international law, international humanitarian law, and human rights law. Madam is a Doctor of Philosophy candidate in Faculty of Law, University of Colombo, and awarded with the scholarship under the HETC project, University of Colombo. Madam has done her postgraduate research studies in law, specializing in international law with special reference to conflict-related displacement and the role of international organizations. And also she has received her Ponambalam Arunachalam Memorial Award, A.B. Kure Memorial Prize, University of Colombo Scholarship, and Mudliar Don Edmund Paris Prize, Mahapola Merit Scholarship during her curriculum. Currently, Madam teaches public international law, international humanitarian law, and human rights law at both undergraduate and postgraduate levels in many law teaching institutions in Sri Lanka. Madam has authored a book named Handbook on Human Rights and has also published book chapter named Human Rights in Prison Administration. Madam has written a number of research articles for journals in Sri Lanka, international journals, and presented them at a number of international and local research conferences. Presently, Madam is working as the editor-in-chief of Sri Lanka Journal of International Law, published by University of Colombo. Vasanta Madam is also the director of the Center of the Study of Human Rights, CSHR, a research institute affiliated to University of Colombo. Madam is the coordinator of Masters in Human Rights programs, that is MHR, in the Faculty of Graduate Studies in University of Colombo. Madam is actively engaged in dissemination of knowledge in the community and in order to, in particular, to the members of the armed forces and the police. Madam is a member of the National Steering Committee of Police Reforms. Madam, we are very grateful to have you with us today, and I request you to grace this webinar with your inputs on today's topic. Now, I would like to request ma'am to take over the session.
Thank you very much for very generous welcome, as well as the note of appreciation. Good morning, namaste, ayubowan. Thank you very much for the very kind invitation extended to me to conduct this collaborative webinar with the Modern Law School in Pune, which is not a strange place to me. I have visited twice to this very prestigious law school. I think we visited in 2020, very early January, before the outbreak of the pandemic, as well as a couple of years ago. So it's very heartening that when I received this invitation to attend the webinar online, and I hope that in future that we should be able to meet up again physically and to conduct much more collaborative work in terms of contributing and sharing knowledge mutually between the two law teaching institutions. With that note of appreciation and thank that I wish to move to the presentation of mine titled The Role of Judiciary in Protection of Fundamental Rights, Issues and Challenges. Now always it's a pleasure and very useful to talk about comparative constitutions and about comparative constitutional experiences between and among countries, particularly in the same region in the world. India and Sri Lanka are being fellow brothers or sisters in the South Asian region. We have a lot of mutual constitutional experiences to be shared, as well as perhaps many issues and challenges could be much similar. However, I am going to talk things in my presentation more about some of the things unique to Sri Lankan experience, because those could be very novel to the participants, and the role of judiciary in protecting fundamental rights amidst the uniqueness of the constitution of Sri Lanka, and to look at how the judiciary, whether judiciary has been able to address those issues and challenges posed by the different landscape situations happen in the years past up to now. all of you are aware that the countries which were the former colonies of the British, once that they gained their independence, were inherited with some of the colonial characteristics of lawmaking in their respective countries. Sri Lanka also started very similar to the Westminster parliamentary model, and also attempted to give more powers to the parliament in lawmaking for the country more than the other two limbs of the government, namely than the executive branch and the judiciary of the country. And we started with strong dualistic model of the country. I hope that you all understand the difference between monism and dualism. So under dualism, it is taken that international legal system and domestic legal system are quite two different legal systems. And if we want to implement international legal obligations undertaken by a sovereign country in their respective territory, they are required to adopt an enabling legislation by the parliament of that country to make it a law. I mean, it is not the case in a monist country where the international law and domestic law are seen as two integrated legal systems. Therefore, any interaction, implementation, enforcement, etc. could be much more easier than that of a country which is known as a dualist country. However, that in my presentation, I wish to say now, Sri Lanka is similar to India, of course, yes, while retaining most of the dualistic features of international legal international implementation, we are trying to provide a mixed model wherever possible when the legislature shows lethargy, or the executive and both the legislature shows lethargy in implementing Sri Lanka's international legal obligation to move towards the monist way, that we call as popularly known also as creeping towards monism. However, moving to the topic of the day, the constitutional recognition of fundamental rights and its implementation, and how the role of the judiciary can be used to make it much smoother and practical, that we find that fundamental rights from the bigger basket of human rights, legally enforceable rights are designated as fundamental rights and included to the constitutional provisions by giving constitutional recognition and acceptance. And when those rights are violated, the remedies also is guaranteed through the same structure of the constitution. So this is very unique to countries with constitutions and constitutional democracy. So the case is similar in Sri Lanka and India. Now I am trying to talk about the attempts made by the successive government since the independence of Sri Lanka. We were 1 year late than India, Union of India, in gaining the national independence and to be a republic as an independent country. Our independence was granted to Sri Lanka on the 4th of February in 1948. So we find a number of attempts were made just closer to the independence of Sri Lanka, and even in the aftermath of the independence of Sri Lanka. So when we look at, we find the 1947 constitution, which helped to liberate the country, known as the Salisbury Constitution. The commission called Salisbury Commission endeavored to harness this constitution, and which lasted till 1972. In 1972, there was a new constitution. We call it as the first Republican Constitution of Sri Lanka. Then 1978 Constitution, which is known as the Second Republic Constitution of Sri Lanka, which is currently functioning subject to 20 amendments. So the Constitution, together with 20 amendments, time to time, based on historical reasons, as well as needs and aspirations, struggles, perhaps as a result of bloodshed, armed conflicts, and other insurrectionist attempts. So then this 1978 Constitution is too much wrecked now, and there is a dire need of having a new constitution to the Sri Lanka. During the time period between 1978 to 2021 that I'm speaking of, there were some other attempts to adopt new constitutions. Therefore, we could see an unsuccessful attempt of having 2000 bill of constitution to make a new constitution, but it was a failed attempt. And again, in 2009, there was another attempt to draft a fundamental rights charter, similar to a Bill of Rights chapter. And in 2015, there was a great attempt to come up with an entirely new constitution. However, with the changes in the government and international and domestic political pressure, all these attempts not become materialized. But again, the current government of Sri Lanka has initiated another attempt of making a new constitution to Sri Lanka. So I wish to share that the government of Sri Lanka appointed 9 expert panel to engage in this endeavor. So I am one of the members of this 9 expert committee appointed by the government of Sri Lanka to come up with a draft for a new constitution. So due to some of the sensitivities and kind of that we need to work hard to achieve the final outcome. So I'm not going to talk much about the contents that we are planning and discussing in consultation with all the stakeholders in the country and elsewhere, and what we are doing right now. But we very frequently meet, and we meet up all the political parties in the country, groups, linguistic groups, because Sri Lanka has different multi-ethnic, multi-cultural and multi-linguistic demography. So we are trying to listen to all the views and to come up with the most practically possible as well as democratic constitution that help to uphold the human rights of all, not only of one community or one set of people, but to have the justice for the people in Sri Lanka. So with that, I thought to talk a little bit about some of those, the journey of constitutionalizing fundamental rights under different constitutions. So I thought to pick 3 constitutions, namely the sovereign Salisbury Constitution of 1947, and the first Republican Constitution of 1972, and the second Republican Constitution of 1978, and key landmark decisions given by the highest apex courts in Sri Lanka to showcase the role of judiciary in protecting fundamental rights under the Constitution in order to provide sustainable solutions to the issues and challenges posed by the application of those fundamental rights in the practical situations. So when we look at the Salisbury Commission and the Salisbury Constitution, so we find that this Salisbury Commission announced in 1944 a prime instrument of constitutional reform to Sri Lanka. And this commission assured in dominion status and independence to Sri Lanka in 1948. And so we find under the constitution of Salisbury Constitution, it was provided a parliamentary form of government for country. At the time, it was named as Ceylon, and for a judicial service commission and a public service commission. I am not going to go through each and every slide in my presentation, but I'm happy to share the PowerPoint presentation with the students who have joined the webinar and all the other participants as well. So for their studies as well as research, if they require and think as useful. But I'll pick some of the key slides to argue for the case of the role of judiciary in strengthening the fundamental rights guaranteed under different constitution of Sri Lanka. So what is salient in the Salisbury Constitution was the safeguarding of minority rights under Article 29, paragraph 2 of the Constitution, which is very, very interesting as well as very unique. So we could see the Governor General, the representative of the British monarchy started, just before the independence, and there has been a Senate and the House of Representatives exercise legislative power. What is again striking here is now Sri Lanka does not have a bicameral legislature. We have a single chamber, but under the 1947 Salisbury Constitution, we had two chambers. I mean, when you are talking about different modalities of power sharing, the minority communities basically and popularly believe that having a bicameral legislature would enable them to go for more power sharing than under a single legislature. So now I am moving to talk about the protection given to fundamental rights, in particular about the rights of the minorities under Article 29, paragraph 1. I hope that you can see this slide. Subject to the provisions of this order, Parliament shall have power to make laws for the peace, order, and good government of the island. This legislative power vested on Parliament was considered as absolute due to the above words. So you can see the Parliament shall have the power to make laws for the peace, order, and good government of the island. So the language is very strong. Sir Ivor Jennings, a very famous constitutional expert of that time, wanted to garner much more constitutional powers and to make the Parliament is having more powers than the other limbs of the government by the inclusion of these words. So the constitutional law students, not only in Sri Lanka, but in India and other countries, perhaps may be very familiar with these two cases decided by the Privy Council, Ibrahim versus the Queen and Lienegay versus the Queen, which interpreted and elaborated the relevant provisions of the Constitution of 1947, known as Salisbury Constitution. In the very famous Lienegay versus the Queen case, it was claimed that the Parliament of Ceylon has the authority even to pass retrospective legislations against the Universal Declaration of Human Rights, principles on natural justice and fundamental rights. However, the power vested on Parliament was limited by Article 29, paragraph 2, paragraph 4, and Article 39. So now this Article 29, paragraph 2 says no such law shall prohibit or restrict the free exercise of any religion or make persons of any community or religion liable to disabilities or restrictions to which persons of the other communities or religions are not made available. I hope that you understand in a multicultural society, such a protection guaranteed for the rights of religious, ethnic and linguistic minorities would help to maintain kind of harmony and conciliation among themselves, and they might have a sense or a feeling that their human rights are protected by the Constitution. It continues to say, confer on persons of any community or religion any privilege or advantage which is not conferred on persons of other communities or religions, or alter the constitution of any religious body except with the consent of the governing authority of that body. So, however, that in any case where a religious body is incorporated by law, no such alteration shall be made except at the request of the governing authority of that body. Provided, however, that the preceding provisions of this subsection shall not apply to any law making provision for relating to or connected with the election of members of the House of Representatives to represent persons registered as citizens of Ceylon under the Indian and Pakistan Residents Citizenship Act. This proviso shall cease to have effect on a date to be fixed by the Governor General by proclamation published in the Gazette. So if we a little bit engage in a discussion on Article 29, paragraph 2 of Salisbury Constitution, Sir Jennings and Marshalls, both are British experts on constitutional law, were of the view that Article 29, paragraph 2 imposed only procedural limitations, not substantive limitations on the Parliament. But there were extremist opinion that it provided an absolute limitation so that no act could be adopted in contravening of this article. And Privy Council decision on Lienegay versus the Queen submitted the limits on the legislative power. So the case that I mentioned, the judiciary that allowed to show the limitations imposed on the legislative power exercised by the legislature, so that the legislature could not adopt any further amendments or any other further legislation in violation of the rights of minorities guaranteed by Article 29 of the said Constitution. So I am now moving to talk about the next constitution in the line, that is the very first Republican Constitution, which actually the Sri Lanka had to envisage a different mechanism in coming up with this 1970 Constitution, just due to the strongness of the provision included in the Salisbury Constitution, and that hardly could be argued that legislature could bring up a new constitution by moving out the protection guaranteed for minority people under Article 29. The students who have studied jurisprudence and studying jurisprudence are quite familiar with the pure theory of law, which is a legal theory promulgated by Hans Kelsen, who is talking about the Grundnorm concept, as well as to get a mandate from the people. So in 1970, when one of the governments called Samagi Peramunu government, which is a coalition of 7 political parties, which came into power in Ceylon. So then they were wondering, that they got a mandate that during the election platforms, they urged people to give a very clear majority of votes to form a government which has more than 2/3 majority in the parliament, and to come up with a new constitution to the Sri Lanka, and to make Sri Lanka a republic, to take away from all the ties knotted with the colonial power. So with that, in 1972, 22nd May, Sri Lanka became a full republic, and this Republican Sri Lanka wanted to have a new constitution to guarantee the sovereignty of people as well as the rights of the people. So I wish to quote from V.V. Mahachan, 1986, who published a book, famous book of Constitutional Law of India. I quote, "Fundamental rights have been referred to as the conscience of the Constitution or the soul of the Constitution," unquote. So then we know how much important to guarantee constitutional fundamental rights under a constitution. Very well respected Chief Justice Bhagwati in Maneka Gandhi versus Union of India expressed as follows, I quote, "Fundamental rights represent the basic values cherished by the people of India since the Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent. They weave a pattern of guarantees on the basic structure of human rights and impose negative obligations on the state not to encroach on individual liberty in its various dimensions." Unquote. Is represented in Parliament in Sri Lanka, participated in the formation of the Constitutional Assembly at the invitation of the then Prime Minister, Madam Sirimao Bandaranaike. I hope many of the older generation people would remember Madam Sirimao Bandaranayake was the first female prime minister of the world, and who had very close friendship with Madam Indira Gandhi, who was the Prime Minister of India during the same time. The parliament met as of a constitution making assembly, not as the parliament per se, in order to adopt the 1972 constitution, and used heavily the legal principles and jurisprudential principles in light of Hans Kelson's pure theory of law. And they took up this challenge of having this mandate to be used to have a new norm, the constitution of the country. So in the 1972 constitution, we have section 18 that declares all fundamental rights and permissible restrictions included in one section. According to section 18, paragraph 1 in the Republic of Sri Lanka, A, all persons are equal before the law and are entitled to equal protection of the law. B, no person shall be deprived of life, liberty, or security of person except in accordance with the law. C, no citizen shall be arrested, held in custody, imprisoned, or detained except in accordance with the law. So likewise, it goes down under section 18, paragraph 1, a couple of fundamental rights, but you definitely would agree with me. This is not very comprehensive. It is not a dedicated separate chapter, not like the Indian Constitution and its fundamental rights chapter, even not like the fundamental rights chapter included in the successive Constitution of Sri Lanka in 1978. However, that this pioneering effort in the 1972 First Republic Constitution is very paramount significance, and it helped to people to make sure that your fundamental rights are guaranteed by the Constitution, and if those fundamental rights are guaranteed, you are entitled for remedies. I am not going to read out the entire Article 18, paragraph 1, but here that I will scroll down the slide slaughter, so you will read it by yourself. Now I will come to the mechanism on enforcement of fundamental rights under the First Republican Constitution. Unfortunately, the 1972 Constitution did not provide for special machinery for the enforcement of fundamental rights against the executive. But the contention that fundamental rights were not justiciable under the 1978 Constitution is also not correct. What were not justiciable were the directive principles of state policy contained in Section 60. Appropriate judicial remedies for the enforcement of fundamental rights were available at that time through writs, actions for damages, injunctions, declaratory actions, etc. The Interpretation Amendment Act number 18 of 1972, passed just before the adoption of the 1972 Constitution, placed serious limitations on the rights and remedies available against acts of the executive. Further, Section 106, paragraph 5 of the Constitution prohibited any institution administering justice from inquiring into any matter concerning the appointment, transfer, dismissal, or disciplinary control of state officers, even if it is submitted when an infringement of fundamental rights was violated. However, that we find one and only case during the entire period of 6 years when the 1972 Constitution was forced, alleging the infringement of fundamental rights is known to have been filed in the courts of Sri Lanka is the case that you see as Gunaratna versus People's Bank in it was decided finally in 1986, but it was brought during the 6 year period of 1972 Constitution was in force. This case was arising out of the bank employee strike of the 1970s. It was a very famous strike in Sri Lanka. The case, a declaratory action was filed in the district courts of Colombo in 1973 at the outset. The district court gave judgment for the plaintiff, but the Court of Appeal reversed it. The Supreme Court in April 1986, after so many years, allowed the plaintiffs appeal against the judgment of the Court of Appeal. So this is the one and only case that we could say, unfortunately, that challenge the executive authority by invoking the rights of the people who were the bank employees who engaged in a strike in 1970s. Dr. Colvin R. De Silva, I don't know whether you have heard about him. He was such a eloquent lawyer, Crown Counsel with great much reputation, was a minister at the time of the strike, ultimately appeared for the plaintiff in the Supreme Court. A long period taken for the final disposal of the matter emphasizes the need to have a special jurisdiction in order to provide quick relief. So since that we are talking about the role of the judiciary, I thought to take this case as an example for the undue prolonged time taken to dispense the justice at the end of the course. The right to move the Supreme Court in respect of the infringement or imminent infringement of a fundamental right by the executive administrative action is itself a fundamental right under the 1978 Constitution. Now I am moving to talk about about the Constitutional Court established under 1972 Constitution. The Constitutional Court under the 1972 Constitution consisted of 5 members appointed by the President. They were appointed by the President for a term of 4 years and could have been removed by the President on account of ill health or physical or mental infirmity only. Any question as to whether a bill was inconsistent with the Constitution was referred to the Constitutional Court by the Speaker. Now let me move to narrate about the protection of fundamental rights under the current Constitution, which is named as Second Republic Constitution of 1978, which is subjected to 20 amendments up to now, and now which is about to be replaced by a new Constitution if asked attempts would become successful. Before the 1977 general election, the United National Party had sought a mandate again from the people to adopt a new constitution. Now you can see in 1970, the other political party, this coalition political party called Samagi Peramunu Party, sought a mandate similar to that mandate again the other mainstream political party during that time that the bi-party system was very strongly happening in Sri Lanka with the electoral system named first past the post system. But now with the representative PR system, proportionate representative system, now we find many smaller political parties also could come into politics and to be elected to the parliament. So we find more than still that we have this by-party system strongly, but we find in addition to the main 2 political parties, we have more political parties coming and making different roles in the political arena. After this mandate sought, a select committee was appointed to consider the revision of the existing constitution. The new constitution promulgated on 7 September 1978 provided a unicameral parliament and an executive president. So it was a quite interesting now, that for the first time an executive president. I think that is a new feature in our constitution, and that is where that we may be different from India and Sri Lanka. We do not have a prime minister who is having powers and headed the cabinet of ministers and who is responsible to the parliament. So we have an executive president who is directly elected by the people of the country. The term of the office of the president and the duration of parliament were both set at 6 years, but now with some of the amendments brought to the constitution of Sri Lanka, the term of the president is now after 19th amendment, and it will be continued in the 20th amendment also. So it is now only 5 years. The constitution provided for an independent judiciary and guaranteed fundamental rights. Providing for any aggrieved person to invoke the Supreme Court for any violation of his or her fundamental rights. The Constitution also provided for a parliamentary commissioner for administration named as ombudsman, who could investigate public grievances against government institutions and state officers and give redress. It also introduced referendums on certain bills. Again, this is a new feature added to the 1978 Constitution. Now, if we want to repeal the Constitution, that we need not only two-third majority to be garnered in the Parliament, but also has to be won by and agreed by the general public in a referendum. So then the process is not that easy. So let me take you to the current constitution of our country and to the chapter 1, which is on the people, the state and sovereignty. So it says Sri Lanka, previously known as Ceylon, is a free, sovereign, independent and democratic socialist republic and shall be known as the Democratic Socialist Republic of Sri Lanka. The Republic of Sri Lanka is a unitary state. I mean that you find that you be in the Union of India, you have a quasi-federal structure in your country, but the Sri Lankan Republic is a unitary state. But I will tell you, after the 13th Amendment, now we have the provincial council system. Some people try to compare and contrast. The provincial council system is as very much similar to your quasi-federal state system. In the Republic of Sri Lanka, sovereignty is in the people and is inalienable. So now it is very clear the sovereignty is in the people, and it is not neither the parliament is supreme, nor any other organ is supreme or sovereign, but people are supreme and sovereignty is vested on people, which is inalienable. The sovereignty of the people shall be exercised and enjoyed in the following manner, in accordance with the constitutional protection and the provisions in the current constitution of Sri Lanka. The legislative power of the people shall be exercised by parliament, consisting of elected representatives of the people and by the people at a referendum. So you will find the constitution allows direct democracy as well, through giving the opportunity and the right for the people to decide certain legislative matters at a referendum, and on the other occasions, the elected representatives of the people will decide and engage in making legislations on behalf of the people. Article 4, paragraph B stipulates that the executive power of the people, including the defense of Sri Lanka, shall be exercised by the President of the Republic, elected by the people. Again, you find the difference between the Constitution of India and Sri Lanka, where the executive power is vested, including the defense, to be exercised by the executive president, elected directly by the people. Then we find Article 4, paragraph C stipulates the judicial power of the people, which shall be exercised by Parliament through courts, tribunals and institutions created and established, or recognized by the Constitution, or created and established by law, except in regard to matters relating to the privileges, immunities, and powers of Parliament and its members, wherein that judicial power of the people may be exercised directly by Parliament according to law. So you find some of the judicial powers have to be exercised through the Parliament. This is the kind of a criticism level against for a future constitution that we should, I mean, it is in public representations made to several committees who engage in making new constitutions, that they were informed that this not between the Parliament and the judiciary has to be taken out to guarantee independence of judiciary. So what is very crucial to our discussion of today is mentioned in Article 4, paragraph D, that is the fundamental rights, which are by the Constitution declared and recognized, shall be respected, secured, and advanced by all the organs of government, and shall not be abridged, restricted, or denied, save in the manner and to the extent hereinafter provided. And the fundamental right, and I'm sorry, Article 4, paragraph E states that the franchise shall be exercisable at the election of the President of the Republic and of the members of parliament at every referendum by every citizen who has attained the age of 18 years and who been qualified to be an elector as hereinafter provided has his name entered in the register of electors. So this is the entrenched provisions included in the constitution. To change any of those entrenched provisions, it is very important, not only 2/3 majority, but even a referendum is required. So that is one of the challenges posed on a constitution making committee, that that we cannot go away or do away with the entrenched provisions unless that it is very sure that 2/3 majority and the referendum could be successful. So now I am moving to another striking feature in the current constitution of Sri Lanka. You being a multi-ethnic, multi-religious country, but still making the constitution of India a secular constitution, you may be very interested to know in chapter 2, the Buddhism is given a very special place. Article 9 states that the Republic of Sri Lanka shall give to Buddhism the foremost place, and accordingly it shall be the duty of the state to protect and foster the Buddha Sasana, while assuring to all religions the right guaranteed by Articles 10 and 14, paragraph 1e. So let me quickly talk about this special status. We are ever grateful to India for having Buddhism during King Dharmashoka's period through his own son, Arahat Mahinda Thero, who came with a team of other Buddhist Arahat monks and who helped to establish Buddha Sasana in Sri Lanka, and it has been cherished throughout, and as a result, majority of the people in Sri Lanka are Buddhist. So this is not about giving a special status or the very different status other than the other religions of the country, but to preserve the historical significance and the identity of Sri Lanka under this provision. Therefore, it is tried to make a balance by saying the right to all religions are equally guaranteed under Article 10 and Article 14 of the Fundamental Rights chapter of the Constitution. However, there are arguments, there are, for merits and demerits of those arguments. However, I am not going to open up to those arguments since I have much more to talk about. So these are some of the challenges posed. Whether to retain Article 9 in a future constitution or not is still under discussion. Now I am taking you to the Fundamental Rights chapter of 1978 Constitution of Sri Lanka. So Fundamental Rights chapter begins with Article 10. I should say Article 10 and Article 11 include non-derogable fundamental rights of the people. So those are not subjected to any limitation, as it is required by the Universal Declaration of Human Rights as well as International Covenant on Civil and Political Rights. So that has been respected by the current Constitution of Sri Lanka and not kept under any limitation. So Article 10 stipulates freedom of thought, conscience, and religion, which reads as follows. Every person is entitled to freedom of thought, conscience, and religion, including the freedom to have or to adopt a religion or belief of his choice. Article 11, freedom from torture. No, this is again a non-derogable human rights. As I told you, this is also not subjected to any limitation. However, that I'll come to the discussion that despite that it is required to be non-derogable and to be respected and to safeguard at the highest level, but unfortunately, all these fundamental rights were subject to much violations in certain occasions, and there are very interesting and very landmark decisions given by the highest court of the country, that is the Supreme Court of Sri Lanka. So freedom from torture is required that no person shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment, but in the cases Gerard Mervyn versus Attorney General and Shreyani Silva versus officer in charge of Payagala police station are some of the examples where the people who were in police custody were brutally tortured, and unfortunately this in Gerard Mervyn case, the person was so much tortured, and he became disabled due to this brutal torture. And although the decision was held on merit to his favor, in later occasion when he was traveling by a bus, he was shot dead by an unknown gunman. And some people try to say that there is a correlation between this murder, and he had another case in a lower court, in the high court, that is a criminal case that was filed against the police officers who inflicted torture on him. In this case, Ryan Silva versus OIC Payagala, this Shreyani Silva was the wife of the deceased person who is known as Lasantha, who was subjected to much torture and who was killed in police custody some time ago. And Shreyani Silva filed this case on her husband's behalf before the Supreme Court, and Supreme Court accepted the locus standi and allowed Shreyani Silva to take up the matter before the courts, and the case was decided on her favor. Then I will move to Article 12, right to equality. But I have something to say here that, I mean, unlike in the Constitution of India, we do not have the right to life provision directly guaranteed under the Constitution. So this is somewhat shocking. And as a result, many people file cases under Article 12, requiring the right to equality to be guaranteed to provide the protection on right to life, as well as many socio-economic and cultural rights when those are violated. So again, I have to say that when we look at the constitutional evolution and the evolution of the fundamental right protection under various attempts, as I mentioned, we find more focus is given on the protection of civil and political rights and very less attention to protect economic, social, and cultural rights under the Constitution of Sri Lanka. However, I mean, although despite that not having direct provisions which guarantees socio-economic rights like South African Constitution or Kenyan Constitution or any other progressive constitution in other parts of the world, and even not like India, that Sri Lanka is much behind, but the judicial activism, the role of judiciary helped to achieve those socio-economic rights, right to life, by invoking the Article 12 on right to equality. So many students, school students who were deprived of right to education, who were deprived of university admission due to executive and administrative actions and their inability to guarantee their rights. This similar to this case, Ruani Pereira versus University Grants Commission, as well as one case filed by Visal Bahashita, a student who was denied due to the change of. I'm sorry, I think someone has to mute his microphone. Thank you. So Visal Bahashita Karunaratna, who filed a case when a government has changed the Z-score formula, that is the technical criteria used to select the entry to the university education, because Sri Lanka, that we are very grateful that not only primary education and secondary education is free of charge, but on a very competitive basis. Tertiary education is also given free of charge in Sri Lanka, which is a very, very unique feature. So in my university, I think there are about 20,000, nearly 20,000 students with more number of faculties, including medical faculty, engineering faculty, law faculty, etc. The students are given the education free of charge. Not only that, they are given bursary and financial scholarship, and free accommodation, hostels, etc. So this is, this is a very great opportunity for the students who are with much high intellect and who can come to the government universities on a competitive basis. But whenever such some problems occur due to the change of government policies and selection criteria, etc., the students have challenged and they were able to enter to the university. Thankful to this Article 12.1. The Constitution guarantees non-discrimination, and no citizen shall be discriminated against the grounds of race, religion, language, caste, sex, political opinion, place of birth, or any one such grounds. But now there are arguments for the new Constitution making committee to include sexual orientation also as a ground for not to be discriminated. We know now India is giving far-reaching judgments by recognizing the third gender rights as well as the rights of LGBT community, etc. So I think Sri Lankan judiciary has to yet to give such judgments to be in par with the jurisprudence provided by Indian courts. So now I quickly move to the Article 12, paragraph 4, which attempts to provide provisions to take affirmative actions and subordinate legislation for the advancement of women, children, and disabled persons. But again, this is another challenge posed to the constitutional making experts committee that, taking the realities in the world and looking at those very good constitutions such as South Africa, Kenya, Nepal, etc., to have separate, specifically tailor-made provisions to protect the rights of women, children, elders, disabled persons, etc. So I think this is a very good move. The ideas are coming from different stakeholders, and it is always important to give acceptance to such proposal for the betterment of such vulnerable categories of people. Article 13 talks about the liberties from the arbitrary arrest, detention, punishment, and protection of retroactive penal legislation. So in our country, again, interesting case decided by the Supreme Court of Sri Lanka. I think this was a very famous incident happened. I don't think that India, that you have had that experience by an Indian, but the Sri Lankan national named Sepal Ekanayaka, who was in Italy and who fell in love with an Italian beauty and who had a child called Free. But with the expiration of visa, the Sepal Ekanayaka had to come back to Sri Lanka. And when he attempted to go back to rejoin with his wife and son, he was not given visa. So we don't accept what he did, but he attempted to hijack an aircraft when the aircraft was take off from Bangkok airport to fly to Italy. He announced that he has a bomb and he is going to blast the aircraft unless he will be allowed to go and join with his wife and son. So this case was quite famous in many jurisdictions. During the time that he hijacked the aircraft, there was no penal law in the country outlawing hijacking of an aircraft. I think that Sri Lankan lawmakers have not even anticipated or foreseen such a crime would be committed by a Sri Lankan by hijacking an aircraft. So then the parliament, due to the dualistic nature, the Minister of Justice and Foreign Affairs had to run to the parliament and to make a retrospective legislation to make him liable for the crime that included to the penal statute. After that, he has committed this hijacking of an aircraft. So with that, he attempted to challenge this retrospective legislation, which was brought, very clear purpose behind to make him convicted for what he has done before the act was adopted by the parliament. But again, this our constitution, I will take you to Article 13, paragraph 6 says, no person shall be held guilty of an offence on account of any act or omission which did not at the time of such act or omission constitute such an offence, and no penalty shall be imposed for any offence more severe than the penalty enforced at the time such offence was committed. Right. So, however, there was a proviso applied in the Constitution. So, with that, if the crime committed, despite the fact there was no law or statute outlawing such a crime, if it is already accepted as a crime at the international law, either by the treaty law or the customary law, having such retrospective legislation could not be considered as a violation of Article 13, paragraph 6. So with that, Sepala Ekanaka could not be successful in this case that he filed against the unlawful, allegedly bringing that retrospective legislation. So Article 14 brings a bundle of civil and political rights as well as some of the economic, social and cultural rights. So here we are now from Article 10 to Article 14 stipulate the most key fundamental rights, which shows that Sri Lanka has attempted to a greater extent to implement Sri Lanka's obligation undertaken under the couple of international human rights treaties, namely under the ICCPR, ICSCR, Child Rights Convention, Women Rights Convention, Convention against all elimination of all forms of discrimination against women, and Convention against all forms of torture. So, however, now those derogable and non-derogable fundamental rights are subjected to some restrictions imposed in Article 15. I'm sorry, not non-derogable rights, but only the derogable rights are subjected to those restrictions imposed in Article 15. So I am not going to talk very much detail about such restrictions that are prescribed by law in the interest of national security, racial and religious harmony, or national economy, etc. And time there could be some emergency regulations. Again, I have to say that we all are very aware about the situation happened in Sri Lanka until 2009. We were under an armed conflict. There was a internal armed conflict happening in the country between the state armed forces and the LTTE, nearly about 3 decades, and it was militarily defeated in 2009. And during that time, the country was mostly governed by the imposition of emergency regulations. So the emergency regulations were lifted, I think, after 2012. That also has to be said. And during that time, there could have been many violations, but due to the invocation of emergency regulations, only non-derogable human rights were protected in its full force. So now I am taking your attention to the remedy for fundamental rights violations. I think I am about to finish my time also. I'll take another 5 minutes to finish my deliberation. So Article 126 of the 1978 Constitution guarantees effective remedy for fundamental rights violations. And we find the Supreme Court shall have sole and exclusive jurisdiction to hear and determine any question relating to the infringement of imminent infringement of executive or administrative action of any fundamental rights or language rights declared and recognized by the Fundamental Rights Chapter and the Language Rights Chapter. So, I mean, there are many criticism about, the inadequacy of the time given. Such fundamental right cases should be filed within 1 month of time when that the person come to know about the alleged human right violation or the imminent infringement of his violation by way of petition in writing by he or himself or by an attorney at law. When you compare with the very developed public interest litigation and locus standi in India, I think that Sri Lanka has a long way to go to be in par with the jurisprudential development occurred in India. Always, although we are not directly bound by the judicial precedents created by Indian apex courts, our judges, our lawyers, our law lecturers, our law students, even the general public are highly appraising the fundamental rights cases given by the Indian Supreme Court. So I would say, personally speaking, that we always encourage our students to read your judgments given by Indian Supreme Court, and those are very illustrative and will provide us a very interesting way forward to amend our constitution as well as to strengthen judicial activism in Sri Lanka. So with that, I think I have come to the end of my discussion. I'm very thankful once again to the Modern Law School for giving us such a valuable time and the encouragement through this wonderful collaboration. And I find that very high attendance of participants to this webinar. So I'm very thankful as the head of the Department of Public and International Law, Faculty of Law, University of Colombo, for selecting the Department of Public and International Law to be a collaborator. And I understand one of our very senior staff members, Mr. Hakim, also will speak after me. So this is a very nice and very friendly gesture from your side to recognize our long-lasting friendship, which should be strengthened for further to engage in more collaborative efforts as such. And let me good luck the principal, the administration of Modern Law School, and all the students and the participants. Greetings from Sri Lanka. Thank you very much.
Thank you, ma'am. We wish you the same. I would like to take the opportunity to thank Professor Vasanta ma'am for her insightful session, wherein she has covered all the important topics relevant to the present webinar. Her session on the topic of role of judiciary in protection of fundamental rights, issues and challenges has broadened our knowledge about the role the judiciary of Sri Lanka plays in handling the issues and challenges posed to them. Now we will proceed with our next technical session. The resource person for this session is Professor Dr. Sanjay Jain, Additional Charge, Principal of Indian Law Society's Law College, Pune. Sir has completed his PhD focusing on feminist critique of judicial process in India and has done a diploma in mental health law from Central European University, Hungary, along with participation in summer school on disability rights in National University, Ireland. Sir has 22 years of experience as a faculty of law, having expertise in comparative constitutional law, administrative law, jurisprudence, international economic law, and feminism. In 2004, Sir is a proud recipient of the President Award for Most Efficient Disabled Employee at the hands of Dr. APJ Abdul Kalam. Sir has co-authored and co-edited the book Basic Structure Constitutionalism, Revisiting Kesavananda Bharati. Sir has participated in 15 international, 45 national, 47 state, and 30 university or local level conferences, seminars, and workshops, and presented more than 50 papers on contemporary legal and social issues. Sir has experience in policy framing and legislative drafting at both state and national levels. Sir has 7 honors and awards and 23 publications to his name. Sir's name is associated with 3 renowned organizations, that is the Tata Institute of Social Sciences, International Constitutional Law Society, and the Maharashtra Knowledge Corporation Limited. Presently, Sir teaches the courses on constitutional law and comparative constitutional law. Definitely, Sir is a true inspiration for all. I would now request Sir to take over the session and give his insights on today's topic. Sir, we'd like you to unmute your audio.
Yeah. Am I audible?
Yes, sir. Thank you so much.
Yeah. I must thank Dr. Adhav Madam for giving me this opportunity to be the part of this very interesting seminar. I congratulate Modern Law College, its staff, and I also congratulate the comparer of this program for having said so many good things about me. I think to begin with, I must applaud Modern Law College for taking cognizance of Asian constitutionalism, because by and large, when we focus on comparative constitutionalism, we are obsessed with Western countries, and we tend to think that whatever happens in Europe or America is the Bible of law, and as if by mastering such Bible, we become the experts in comparative constitutional law. But I know scholars, like just now I was listening to Professor Vasanta, or my friend Dinesha is there in Sri Lanka, my friend Kumar Singham, who talks about uh, East Minstrel parliamentary form of government. His book is very famous. There are lots of scholars around Asia, in Nepal, in other countries, and therefore I think I congratulate you for showcasing the Asian scholarship through this webinar. With a very heavy heart, I have to begin this webinar, my presentation in this webinar. I want to dedicate my talk to my teacher, who was more than father to me, my mentor, Dr. Deshpande, who recently passed away in a very untimely mode, giving tremendous shock to all of us. And frankly speaking, it is not easy to gather thoughts and speak on a complicated topic like fundamental rights and comparative constitutional law trends. But sir used to always tell me that only during the challenge, when you face challenges, when you are facing crisis, during crisis you can blossom. During crisis, probably you can deliver what you would not have delivered in normal times. So let me try in my own modest way to do justice to this very interesting topic. By the way, I also would like to welcome my friend. I don't know whether he has joined, but he was supposed to join, my friend Rahul Bajaj, who is a Rhodes Scholar and who is presently clerking with Justice D.Y. Chandrachud. And when he came to know about this topic, he was very interested and to join the seminar, and therefore I shared the link with him. Hopefully he has joined. Now let me start directly with my topic. Let me first argue that when we adopted our constitution in 1950, we had what I call, or what I characterize as, the Indian model of fundamental rights. So before I talk about the comparative trends, let me briefly explain the Indian model of fundamental rights. So Indian model of fundamental rights was based on very conventional idea that every article has a distinct fundamental right, and accordingly, vis-a-vis a particular fundamental right, the concerned article has to be interpreted. So suppose you are talking about right to life and personal liberty, you will read Article 21. Suppose you are talking about right to freedom of expression, you would read Article 19(1)(a). So article specific approach was there to the study of fundamental rights to the interpretation of fundamental rights, and in its first momentous decision in Gopalan case. All the judges writing separately, delivering their opinions by, you may say, 5 to 1.5, because 1.5 Justice Mahajan opinion partly dissenting, partly concurring. By and large, the view was taken that we should not collapse the different fundamental rights into one another, and that every fundamental right has been very neatly and clearly delineated in the different provisions of Indian Constitution. That was the view. This view was also then echoed in a very famous case, All India Bank employees case, Justice Iyengar. He said that if you collapse the neatly delineated provisions into one another, then you will destroy the carefully prepared constitutional design of fundamental rights. And he warned against, reading articles together or convergence of articles of fundamental rights. So, in short, the Indian model of fundamental rights, the first feature of the Indian model of fundamental rights, as it was evolved, as it appeared at its surface, was that we have to attach importance to the text of the Constitution. Another interesting feature of the Indian model of fundamental rights was that just as Part 3 recognized a number of fundamental rights, it also categorically recognized with the adoption of First Amendment to the Constitution that all these fundamental rights can be infringed. That is to say, fundamental rights violating laws can survive the scrutiny of judicial review if they are inserted in 9th schedule. So you had a very peculiar situation where both fundamental rights respecting and fundamental rights violating laws would survive together. So this extraordinary contradiction was conceived in the Constitution by none other than very people who had designed the Constitution. No less than Dr. Ambedkar was also one of the supporters of 9 schedules, right? So that is another feature of the Indian model Constitution. So simultaneously, coexistence of fundamental rights conforming and fundamental rights violating laws could survive in India. The next interesting feature of the Indian model of fundamental rights was that apart from 9th schedule, other articles, there were other provisions like articles 31A, B, 31A and C, which allowed the parliament to make inroads into rest of the fundamental rights, right? Article 31A dealt with right to property, and Article 31C, Article 31A dealt with urban land reforms, and Article 31C dealt with giving primacy to certain directive principles over fundamental rights. So this was another interesting feature of the Indian model of fundamental rights. The next interesting feature of Indian model of fundamental rights was that before the First Amendment, there were hardly any restrictions. There was hardly any room for imposing or curtailing freedoms under Article 19. But with the introduction of the First Amendment, and there is this very interesting book written by Tripur Daman Singh, 60 Stormy Days, wherein he talks about the history of First Amendment. And in my opinion, the history of First Amendment is as notorious as the history of the 42nd Amendment. With the First Amendment, not only a number of restrictions were introduced to various freedoms under Article 19. But initially, Nehruji was not even ready to use the word reasonable. He wanted to confer blanket power on the parliament to impose restrictions on various freedoms. But with the insistence of Shyama Prasad Mukherjee, the word reasonable was added. So reasonable restrictions regime was introduced by the First Amendment. So originally it was not there. Again, see the paradox, very people who wanted Indian citizens to enjoy fundamental rights, those very people uh, in together are coming together to deny the fundamental rights to the citizens or curtail fundamental rights of the citizens, giving vast powers to the uh, now now the next important feature of our fundamental Indian model of fundamental rights was that uh, all fundamental rights were supposedly limitations on the legislative powers of the parliament and the state legislature, and therefore under Article 13(2), there was an injunction against enacting any law in violation of fundamental rights. Then the next interesting feature of the Indian model of fundamental rights was that mostly the fundamental rights were supposedly to be exercised against the state. So uh, there was hardly any controversy whether or not fundamental rights are available against the state, but it was not beside the controversy to argue that uh, uh, all fundamental rights were equally available against the private parties. So what is known as the horizontal effect. I will come to that. Then another interesting feature of Indian model of fundamental rights was in same fundamental right, you have different provisions. One provision recognizing fundamental right and another provision allowing parliament to override the fundamental. For example, Articles 15(1) and 15(2), injunctions against non-discrimination, and then there are exceptions. Nothing in this article shall prevent the parliament from making any laws for making any special provisions for women and children, or making special provisions for the empowerment of SCs and STs. So this is another peculiarity. First, you recognize fundamental rights, but then you also allow again parliament to make inroads into it, right? And this is very peculiar to India. You don't have any other constitution around the world having such long, lengthy provisions dealing with, say, non-discrimination and affirmative action. It's very peculiar to India. Then another interesting feature of the Indian model of fundamental rights is the language of non-discrimination. I think, barring a small country, I've forgotten the name of that country, but I've done research. Barring that small country, nowhere around the world you have the kind of language used to deal with non-discrimination. Because what our constitution say, no citizen shall be discriminated in India only on grounds of, or grounds only of sex, caste, place, race, or any of them. So grounds only of. Now this peculiar terminology of grounds only of, right, is an indigenous creation. You don't have such language. You don't find any other place, any other constitution around the world where this kind of language is used, barring that small country. I've forgotten to mention you. I forget its name. From where we got this? If you see the constituent history of fundamental rights, till the very end, only grounds only of, the terminology of grounds only of was not there, right? If you read the Ambedkar's draft, or if you read Sardar Patel's draft, or for that matter, so many other stalwarts, when they prepared their drafts and they presented the same to the Constituent Assembly, nobody wanted a qualified non-discrimination clause. But B.N. Rao, while renumbering the provisions of the Constitution and in the guise of making cosmetic changes in the Constitution, introduced this phrase "grounds only of," and the origin of this provisions you can find in Section 298 of Government of India Act 1935, and then its precursors like 1950, right till 1858, you can find this kind of terminology. So this Victorian terminology of non-discrimination, unfortunately, was perpetuated by B.N. Rao, or any of them is a very important and a very revolutionary clause, because or any of them means either on single grounds or on all the grounds taken together, discrimination is prohibited. But grounds only of is very disappointing, because if if the state is able to establish that discrimination is not only on the grounds prohibited, but there are some other grounds which are not in the list, then the state might get away. For example, suppose I say that your entry is not barred in college because you are women, because that would mean the entry is barred only on the ground of sex. But I say because your age is problematic, or if it is said that okay, uh, 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 your background, your accent of speaking English is problematic, right? So they will say, okay, it's not made only on the ground of sex, but on other grounds. So, friends, this is what I call Indian model of fundamental rights. Very traditional, very peculiar, and in some respects exceptional, particularly when you look at the peculiar drafting of Articles 15 and 16. Now, how it has undergone change, how it has survived the tyranny of time. And here I want to now borrow the work of Professor Kai Muller in his famous book, Global Model of Fundamental Rights. Kai Muller argues that gone are the days when fundamental rights would be understood in a philosophical sense. So what is the philosophical version of fundamental rights? Fundamental rights are certain selected interests elevated and given special treatment, right? And therefore they are normatively heightened, right? Professor Kai Muller says that this understanding of fundamental rights, that okay, fundamental rights are certain special interests which are singled out for special interests which are worthy of being called as rights because they are exceptionally ethically important. He says all those things are outdated. He argues that post World War II, if you look at the constitutions around the world, the trend is different. There is what he calls rights inflation. Rights inflation means almost every interest is being elevated as right. So you have right to food, you have right to feed pigeons, you have right to enjoy, you have right to sleep, you have right to clean environment, you have right to sing, you have right to dance, so on and so forth. So everything, now every interest is said to be captured by the magical notion of right. Now the question is this globalization of rights and seriously challenging the philosophical notion of rights and attaching almost every interest the label of rights, whether it has any, what are other aspects, what are the other features of a global model of fundamental rights, if it is a global model, if it is accepted that, okay, this global model exists. So he says that dominant discourse on fundamental rights prior to the introduction of global model had four distinct features. So what were those four distinct features? Firstly, the only certain interests were elevated as fundamental rights. So for example, right to life or freedom of religion or freedom of expression, uh, these interests would only be acclaimed as rights. But like right to sing or right to dance, it would be laughable prior to the Second World War if you would characterize such interests as right. So that was the first point. The second point was generally the fundamental rights were understood as negative obligations, right? The state would be merely restrained from doing a particular thing. The obligations were injunctive. You will not stop people from enjoying their rights. So obligation was negative. Obligation was by way of restraint rather than by way of positive obligation. Thirdly, the obligations were mainly, the fundamental rights were mainly confined to the relationship of citizen and his state. So, for example, if you would say that my father has violated my fundamental right by not allowing me to marry the partner of my choice, if you would have said this prior to Second World War, people will laugh at you because it is a private relationship which is beyond the realm of fundamental rights. And lastly, because these fundamental rights are special in character, because the fundamental rights are limited to certain extraordinary interests, uh, they are normatively heightened. Their value is normatively heightened. So, for example, if you read Ronald Dworkin will say rights are trumps. So all considerations, all other things being equal, if you are talking about rights, then they will prevail over the countervailing considerations, right? So rights are trumps. So if you are talking about freedom of speech and expression, it is a trump over all other considerations, right? Because the right to freedom of expression is inalienable. People like Stephen Griffin or Nozick, with their idea of judicial minimalization, laissez-faire philosophy. All these people will attach extraordinary importance, inalienability, transcendentalness to fundamental rights, and therefore these fundamental rights will have extraordinary importance. These fundamental rights would be seen at a different pedestal than the ordinary rights. But as Kai Muller suggests, in four ways, this so-called conventional philosophical model of fundamental rights has undergone change. So far as the second point is concerned, second and third point, that fundamental rights should be understood only in terms of negative obligation. Now, there are various constitutions around the world wherein it is believed that fundamental rights do not merely result in negative obligations, but if you want to ensure effective enjoyment of fundamental rights by citizens, then positive obligations and socio-economic rights, socio-economic entitlements must also be connected with fundamental rights. Now take example of right to education, for example, Article 21A. Now this is nothing but impact of comparative trend of fundamental rights. 21A would not have seen the light of the day prior to the Second World War in any constitution. But now we have free and compulsory education guaranteed to children between the age group of 6 to 14. Now, in order to give free and compulsory education, you need schools. In order to run the schools, you need teachers. In order to have schools and teachers, you need land, you need money, so on and so forth. So, mind you, although you are talking about right to education, it is a bundle of many corresponding rights, many connected rights. So therefore, the second point, the conventional view that fundamental rights were merely negative, that view has received a serious challenge. Similarly, the third view that fundamental rights are only available against the state. This view also seems to have been challenged in many jurisdictions. So take example of India itself, Article 17, untouchability is abolished. Now, who practice untouchability? State does not practice untouchability. Untouchability was practiced by people inter se, by citizens inter se, citizens amongst between one another. So by abolishing untouchability, what you have done, you have regulated the horizontal interaction of citizens. You are clearly saying by abolishing untouchability that if you are found practicing untouchability after the adoption of the Constitution of India, then you have committed a constitutional wrong. It is not a private wrong. It is not a tort to practice untouchability any longer, right? Unfortunately, Kai Muller, in his global model of constitutional rights, and here I am critiquing him, in his Eurocentric obsession, he forgets to mention India. He says Germany was the first case introducing horizontality. He's wrong. He's wrong. India was the first case because Article 17, Article 15(2), can you stop? Can a hotelier stop a person belonging to SC or ST from entering into his premises? So when you become Eurocentric, when you feel that everything happens in Europe is only comparatively worth taking cognizance, then this is a problem. So this is what I called the alienation towards East. Similarly, in my opinion, we are also guilty because we don't challenge the Western scholars. We simply adore them. Okay, Kai Muller is great because he has written this book. But what about pointing out his mistakes if he has committed mistakes? So that is another point. The last so far as the first and the fourth points, according to the conventional view, because only certain interests are fundamental rights, so they are extraordinary and they will trump over all other considerations. Whereas in the global model of fundamental rights, since almost every interest is now captioned as right, so therefore it has only prima facie character. So okay, let me exemplify this. So I have right to freedom of expression. Yes, you have. Prima facie, you have right to freedom of speech and expression. But whether right to freedom of speech and expression is definite right, the answer is no. Because if this right has to be interfered, then at the justificatory stage or at the justification stage, the state has the power to interfere with it. State does not have the power to completely violate it, but state can definitely interfere with such a right. So what is an interesting point we are getting when we are comparing the philosophical model or conventional Indian model with the present global model, is that okay, all fundamental rights are there, but these all fundamental rights are merely prima facie. And just as they are respected as rights, they are also to be balanced and interfered with when there is a conflict between fundamental right of one person with the fundamental right of the other, or when there is a conflict between the fundamental rights of citizens and the interests of the state. So see the cascading effect. So just as we don't have now hesitation in recognizing any interest whatsoever as right, similarly, we also don't have any hesitation in interfering with such an interest. But in philosophical model of human rights or fundamental rights, once you regard a right as a fundamental right, then it is very difficult to make any inroads. Now, if I were to give you the example from India to establish my point, look at Article 25. freedom of religion, it is subject to a number of restrictions, subject to public order, morality, health, and other fundamental rights, for example, isn't it? Article 19, subject to number of reasonable restrictions, right? So therefore, only prima facie you can claim that you have fundamental right. But does the label of fundamental right to an interest prevent the state from making interference with the same? Yes, it doesn't, so long as state is able to justify. So therefore, the fourth point, unlike the philosophical model where there was hardly any room for making intervention with the or interference with the fundamental rights, the present structure of global model of fundamental rights introduces the doctrines of proportionality and balancing. So as long as you are able to justify the interference with the fundamental rights can be regulated. But at what condition? What is the condition? Condition is that the justification for the interference of fundamental rights has to be proportional, right? Now here, there is a clear-cut radical departure in India too from the typical Indian model of fundamental rights. Whether our constitution ever talked about proportionality, whether our constitution ever talked about balancing, whether the words balancing and proportionality did even figure in any of the provisions of the text of our constitution, the answer is no. But under the influence of the comparative constitutional law, if you read Aadhaar judgment, if you read the dental college judgment, or for that matter, Puttu Swami judgment, there are numerous references to the doctrine of proportionality and balancing. Now, what is the impact of doctrine of proportionality and balancing? The impact is that we no longer attach importance to the text of the constitution. Because if you attach importance to the text of the constitution, then you can use only Article 19(2) to restrict freedom guaranteed by an Article 19(1)(a). But nowadays, what is the fashion? Nowadays, the fashion is that you don't either claim that your Article 19(1)(a) only is violated, nor state also claims that it is restricting only Article 19(1)(a). Because nowadays we go for integrated reading. We said that when my freedom is violated, my equality is also violated and my liberty is also violated. Maneka stuff. Articles 14, 19, and 20. So clearly, therefore, you're saying bye-bye to Justice Iyengar, you're saying bye-bye to All India Bank Employees Association ratio, and now you are talking about the convergence of various provisions to create new fundamental rights. And in fact, Professor Ishwara Bhatt has written a very interesting book on interaction of fundamental rights. Now, I remember in this context a very interesting decision of German Constitutional Court in Luth case, given as early as in 1953, wherein the German Constitutional Court said that, I remember it's not Luth case, it's another judgment. Luth case I will talk about later, wherein German Constitutional Court said that Article 1, Clause 2 confers on every citizen freedom to develop his or her own personality. So court said that freedom to develop one's own personality means freedom of action. And court said that in fact, in normal language, what it means is right to do whatever one pleases, right? So look at the liquidation of interest theory. Whatever you want to do, you can do under the caption of right to freedom. Same thing with some qualifications has happened with European Court of Human Rights, ETHCR, right to enjoy private life under Article 8 of European Convention of Human Rights, and it is said by the tribunal, European Tribunal on Human Rights, that when we talk about the right to private life, you have to take into account both physical and psychological aspects of the personality of an individual. And when you further fragment the physical and psychological aspects of the personality, so many other, like health issues, bodily issues, uh, uh, language issues, so on and so forth. Everything connected to the private life, often sexual issues, right? All those issues, they attract the protection of private life. So, European Court of Human Rights has used Article 8, and the counterpart of Article 8 and the German Constitutional Court is what in India, Article 21. You name it, you have it, right? All kinds of rights have been recognized by using the vehicle of Article 21. As if Article 21 does not have any threshold. Right to life and personal liberty, as if it would include almost everything. And the process started with Maneka, right? Right to dance, right to sing, right to food, right to eat, right to sleep, and so on and so forth. Therefore, now what is happening? More you expand the scope of right, more also needs to more you have to also recognize the powers of the state to regulate such rights. For example, right to education. In Mohini Jain, right to education was recognized by the court. But when court said that every citizen has right to education, did court realize the implications of its judgment? Because had the state accepted right to education at its face value, as laid down in Mohini Jain, probably from KG to PG, every citizen would have got right to free education. Country would have gone bankrupt. Therefore, there is interaction between the state and the court, and you have 86th Amendment and you have Article 21, right to free and compulsory education. Right? Then another interesting aspect where the global model and the philosophical or conventional model can be compared is in the context of socio-economic rights and positive obligations. Now, suppose a woman is raped during night because she is found wandering or found, found moving alone in a car, or maybe found in a drunken state, and then people take advantage and she's molested. Now, the typical view would be what she was doing in the night. She was bound to be raped because she exposed herself to the hostile environment of the rape. Right? That is a conventional view. But what about the assumption that just like men who can roam around in the night, freak out in the night, why women cannot freak out? And if they are freaking out, should they be raped or should they be protected? Should there be some positive obligation on the state to ensure that no one is appropriated against his or her will? Isn't it? So in South Africa, the positive obligations are clearly recognized. Articles 27, 28, articles, I think 36, 37, and 39. I may be wrong on articles, but you are right of housing, right to water, right to social security, so on and so forth. However, and similarly, right of positive general duty. Now, some people may argue, where is the textual justification for imposing positive obligation of the state? You are saying, sir, that women should be given protection during the night, but what is the language? The language is clear. No person shall be deprived of his right to life and personal liberty, save as procedure established by law. So obligation is negative. Where is the positivity? Where is positive obligation? Now, if you read Article 32, if you read the first clause of Article 32, rights conferred by this part are guaranteed. So what do you mean by guaranteeing rights? If state is guaranteeing rights, does guarantee means merely inaction, or whether guaranteeing also means action, positive action, anticipation, right? Therefore, positive duty, or what is known as the protective duty. So in 1973, German Constitutional Court, in an abortion case, it said that although the woman might have a choice to go for abortion, but what about the life of the fetus? So it derived the protective duty from right to life under Article 2 of German constitutional law, and said that state is under obligation, positive obligation, to stop the feticide. Right? A very controversial decision, but nonetheless a decision given by the German Constitutional Court. So positive obligations are there, socio-economic entitlements are there, and in India, we have followed the comparative trend. Nowadays, what happens? If you recall the Champakam Durai Rajam, the notorious Champakam Durai Rajam case, what Supreme Court said: directive principles and fundamental rights are poles apart. They don't have any connection whatsoever with one another. But what is the position after Keswanand Bharati? Directive principles of state policy are the part of the basic structure of the Constitution. If fundamental rights are the means, directive principles are the goals, right? So therefore, this so-called dichotomy between civil and political rights and socio-economic and cultural rights is completely challenged, is completely almost done away with by the Constitution. Therefore, now it is also said that when you interpret Part 3, you can interpret Part 3 in the light of Part 4. So what you are doing, what you cannot do directly, you are doing indirectly. Okay, I cannot enforce directive principles directly. I will use Part 3 as a vehicle to pour the contents of Part 4 into it, right? So Article 21, if you want to enlarge, if you want to go for a meaningful conception of life, right, then you have to interpret it in the light of directive principles. So pre-legal aid. If you don't give pre-legal aid, the life of a prisoner will become hellish, isn't it? So this is nothing but the impact of the comparative constitutional law. Then another interesting aspect is about recognizing the rights of certain sections of the society which were completely alienated. So take the example of homosexuals or LGBTQ. The norm in India, till we were obsessed with the Indian model of fundamental rights, was that only one sexuality, that is to say the one form of sexuality, that is to say the heterosexuality, should be recognized, and no other form of sexuality should be recognized. In fact, it was visited with penalty. And only just 2 years ago, if I'm correct, Justice Chandrachud, in his memorable tone, he said the 3 generations of this country owes an apology. You have stopped people from loving one another. How can you say that to love, you need to follow a particular form of sexuality alone, right? Very important and very valorizing tone in which he elevated right to love, right? Right to love. Could you imagine right to love without the impact of the comparative constitutional law and global model of constitutional right? How to enforce right to love? Suppose I want to go to High Court or Supreme Court and want to enforce my right to love. How to enforce it? Everybody may have his or her own means to enforce it. So, friends, it's only a prima facie right. In the name of right to love, you can't do whatever you want, right? So that's what Justice Chandrachud said, that, okay, we recognize sexuality. But recently you have read a judgment wherein court has very clearly said that that does not mean that right to marry, so far as homosexuals are concerned, is a fundamental right. It may be a controversial view, but still there is a reasonable disagreement in the society about whether or not we should open up our families to families beyond heterosexuality, right? Matter is still in the zone of deliberation. So the point which I was trying to make is this, that comparative constitutional law has come to the aid of those who were alienated, who were isolated, who were forgotten minorities, right? Disabled, for example. Look at the Vikash Kumar judgment recently delivered by Supreme Court. Why Supreme Court did that? Obviously, under the influence of comparative constitutional law. Equality, if you want to interpret, equality by itself is a very crude concept without any content. It is parasitical. It depends for its effective use on how other rights are given. So suppose you say that I want, Mr. Jain, I want to treat you equally. But you say you are blind, therefore I can't give you this, I can't give you that. What kind of equality you are practicing? You are saying you are practicing equality, but you are saying that, okay, you are blind, therefore I can't give you this or I can't give you that. So what Justice Chandrachud did? He used International Convention on Rights of Persons with Disability, and introduced reasonable accommodation as an individualized duty to make what sounded formal equality becoming substantive equality. Right? He said, if you want blind people to be judges, then don't look at their blindness. Look at the inadequate default structures. Why blind people cannot become judges in India? Because your infrastructure is poor. Because your sight is limited, right? Your vision is limited. Because you have designed the entire structure keeping in mind only the able-bodied. So by default, you are exclusionary, isn't it? From where this point came? This point would not come from the Indian model, because the Indian model of equality was a model based on reasonable classification, a model based on formal equality. Even if you ask anybody in 1960 whether classification between blind and sighted is reasonable, he will say without wasting a minute, yes, why not? Blind people and sighted people are different categories. Why? Because those days disability was perceived as a medical issue. But now, no longer disability is seen as a medical issue. Now it is seen as a social issue. Why we are disabled? Because society has created barriers. And because of social barriers, we are disabled. Why this has happened? This has happened because of the influence of comparative constitutional law. Now, quickly, let me talk a little bit about horizontal effect. Now, general view is that fundamental rights or public law is an instrument to regulate the relationship between the state and the citizens. But what if public law or constitution has set up certain objective values? For example, if you look at our preamble, there are certain values which ought to pervade not only public law but entire legal order. For example, the value of fraternity, the value of human dignity. Suppose, take an example, ki XYZ is telling to ABC, okay, you carry maila from my house on your head and I will give you 10,000 rupees. ABC is a poor scavenger, a very distressful word, but just I'm giving you as an example. Now, will you dismiss the matter as a pure contractual transaction between the two individuals? Or will you visit it in the light of the constitutional value of human dignity? And if you want to visit it in the light of the constitutional value of dignity, then don't you think that horizontal effect has to be given to the constitutional values, to the percolation or transmutation of constitutional values into private law, isn't it? So I want to use the analogy of radiation. Just as radiation spreads, constitutional values are also radiating, right? They cannot be confined to only to public law. They are bound to infect, but in a positive sense, even the private law. And we have so many cases, right? Hidayah. What Kerala High Court had done? Kerala High Court tried to intervene in a marriage between two adults, saying that woman did not have control over her mind. The girl did not have control. She was a medical doctor. In the 21st century, Kerala High Court was talking this nonsense. When the matter went to Supreme Court, what happened? Horizontal effect. Even father can be a violator of fundamental rights. Michael Foucault says, nature of power does not matter. What matters is abuse of power. And if power is abused, rights are violated. Right? So don't be under the false impression, artificial impression, that public power is the root cause of violation of fundamental rights. More than public power, I think the private use of public power, or for that matter, using private power in the garb of public power, is also the reason for violation of fundamental rights. And all these points are clearly covered by the global model of fundamental rights, because governmental lawlessness and lawlessness of certain vociferous groups, certain vocal groups, right? So, for example, cow vigilantism, right? Cow vigilance, right? So, friends, therefore, my submission is, now our constitution does not characterize, fundamental rights as absolute. All fundamental rights are merely prima facie. Secondly, our constitution no longer confines the interpretation of fundamental rights article specific. Now we believe in interaction of fundamental rights. Now we believe in convergence of fundamental rights. Therefore, I don't know whether you call this as dialectics or dynamics or detraction from the text of the constitution. I don't know what is this. But what has happened is definitely spectacular. Just as every interest can be elevated as a fundamental right, similarly, because we have now almost lost the threshold of right to life, everything can be circumscribed, and everything can be packed under the notion of right to life. Therefore, therefore, just as fundamental rights have prima facie character, similarly, the powers of the state, as long as they are able to justify, as long as they are able to exercise these powers proportionately. Now, just quickly, in a minute, what is proportionality? First of all, the goal which you want to deploy for making inroads into fundamental rights, it should be a legitimate goal. Then the means by which you are trying to achieve the goal, that means must be a least restrictive means. The means must be such that it should result in minimum violation of fundamental rights. And then you have to also establish the necessity and suitability of the action, right? In a very simple language, I've tried to provide you the proportionality analysis. So therefore, the last point is, just as the fundamental rights are prima facie, the powers of the state are also acceptable only and only till the state is able to perform the burden of passing the test of proportionality. Now, what values are promoted by global model? Global model promotes the value of democracy. Global model promotes the value of diversity. And global model also promotes a very proactive and a very zealous judiciary. I don't know whether I have been able to do justice to the topic which was given to me. My mindset was not very apt, but I thought that I would try my hand and try and develop what I advocated, the Indian model of fundamental rights. I thank the organizers for giving me this opportunity to speak to my mind and put across my views. Thank you very much.
Thank you so very much, sir. You had asked a question that whether you have whether you have done the justice or not. You have done a complete justice, sir. Thank you so very much, Dr. Sanjay Jain, for enlightening us on Indian model of fundamental rights. He discussed various important features of fundamental rights. Comparing the restrictions of fundamental rights in the ninth schedule, and also correlating it with the directive principles. He spoke about the proportionality and balancing of fundamental rights, though it is not written, but many judgments we can see, the latest judgments we can see that proportionality and balancing of the fundamental rights we have been come across. And also he spoke about the positive obligation of a state. So thank you so very much, sir, for enlightening us on the comparative analysis of the constitution across the globe. Now let's move to the last technical session. It's my pleasure to invite Mr. Hakim, M.A.M. Hakim. He has done his LLB from Colombo University and went on to do LLM in international law from the University of Malaysia. Sir is an attorney at law of the Supreme Court of Sri Lanka and is a senior lecturer grade 1 in public and international law attached to the Department of Public and International Law in the Faculty of Law, University of Colombo, Sri Lanka, and he's a deputy director of the Center for Study of Human Rights, a research institute affiliated to University of Colombo, Sri Lanka. Currently, Sir is member of the advisory committee on Muslim law of Sri Lanka and technical consultant and transformation of criminal justice system in Sri Lanka, and community corrections order reforms to the Ministerial Consultative Committee, the Parliament of Sri Lanka. Professor Hakim teaches public international law, international humanitarian law, and human rights law, both at the undergraduate and postgraduate levels in many law teaching institutions in Sri Lanka. Sir has authored and published research articles in local and international journals, translated a number of international conventions on human rights and humanitarian law, and presented several research papers at a number of international and local research conferences. Sir is academic coordinator of the Executive Diploma in Human Rights and has served as the academic coordinator of the Masters of Conflict and Peace Studies programs of the Faculty of Graduate Studies at the University of Colombo, Sri Lanka. Sir, it's our pleasure to have you, and we would love to listen from you, sir. Over to you. Thank you.
Thank you. It's good afternoon to you all. Can I share my slides?
Yes, sir.
Yes, thank you. It's my topic on this discussion today is about vulnerable groups vis-a-vis fundamental rights. I think almost all the participants are now maybe a vulnerable group because listening to very in-depth and very productive session since morning. It's an ideal topic. At the last, we are talking about vulnerable groups. Right. Thank you. This is a brief outline of my presentation. Am I audible? Clear?
Yes, sir.
Yes, sir.
Okay. Thank you. Thank you. Introduction is a concept of human rights. I will briefly touch on this topic, and then we'll go for defining vulnerable groups, then fundamental human rights of vulnerable groups. Then I have a slight comparative discussion on I'm going to share with you some provisions of the international Indian Constitution, South African Constitution, and Sri Lankan Constitution, and we will touch on European jurisdiction as well. Then emerging challenges and conclusion. So I will not take long time, and I will try to share some slides, some thoughts about vulnerable groups' rights under this system. Basically, we all know that the concept of human rights are commonly understood as being those rights which are inherent in the mere fact of being a human. The concept of human rights is based on the belief that every human being is entitled to enjoy his or her rights without any discrimination. human rights differ from other rights in two respects. Firstly, they are characterized by being, that means inherent in all human beings by virtue of their humanity alone. And second, inalienable. It cannot be separated from human being. The third one, equally applicable to all, wherever, everywhere, anytime. It will be applicable human rights. Secondly, the main duties deriving from human rights and fall on states and the authorities or agents, not on individuals. Now we can think about the concept of duty bearer and rights holder concept here. Human rights and vulnerability. What do we mean by vulnerability? Human rights are applicable to universally to all. The process of identifying vulnerable groups' human rights generated from the pressing realities on the ground that stem from the fact that there are certain groups who are vulnerable and marginalized, lacking full enjoyment of a wide range of human rights, including the right to political participation, health and education, etc. Right. So in this line, we can see vulnerable groups means starting from the Latin term vulnus, which means wound, right? Easily getting wounded. The term vulnerable groups is usually synonymous with the groups at risk. Risk of what? Violation of fundamental rights. So what we can talk about, so we can have a self-assessment. Am I a vulnerable person? It's simply we can talk. Vulnerability speaks to our universal capacity for suffering in two ways. First, I am vulnerable because I am dependent upon cooperation of others, or with the support of others only I can function. Second, I am vulnerable because I am easily violable. I am permanently open and exposed to hurt and harms of various risks. Then I will be an individual of that vulnerable groups. It's a simple assessment to define who is a vulnerable person. The meaning of vulnerability in the universal sense, it comes no surprise that harm and suffering features certainly in most cases of vulnerability. A group is generally considered vulnerable because there is a good reason to suspect that the individual in the group may have special difficulty in enjoying basic rights and freedoms like others in the larger society. Further, we will see vulnerable groups to abuse of human rights. Now we can see who are the groups in our society, who are vulnerable groups. I have a long list of group of people, groups that are structurally discriminated against, and groups that have difficulties in defending themselves and are therefore in need of special protection. I start from one: women and girls, children, refugees, IDPs, internally displaced persons, stateless persons, national minorities, indigenous people, migrant workers, disabled persons, elderly persons, and HIV positive persons or AIDS victims, gypsies and other aboriginal people, LGBT and others, there's a huge emerging group, human rights activists and journalists, and other new vulnerable groups. This segment of population, we identify vulnerable groups because they are structurally discriminated against, and groups that have difficulties in defending themselves and are therefore in need of special protection. So now when we talk about the definition, the groups that experience higher risk of poverty or social exclusion than the general population are vulnerable. Generally, we call it ethnic minorities, migrants, disabled person, homeless, those struggling with the substance of abuse, isolated elderly people, and so on. We call them vulnerables. There's another definition. People who are longer term unemployed, and also others who are inactive but not registered as an unemployed. It should include workers who are in some form of their employment but at a high risk of losing their jobs. So it is therefore a very heterogeneous group. Those members share perhaps only an involuntary character of their present status. This is a comment, very important comment. There is no universal or common definition of vulnerability, but in relation to employment, in the concept of vulnerability, groups denotes a risk of marginalization from the labor market, social exclusion. Right, fine. Further, certain groups in the society often encounter discriminatory treatment and they need a special attention, avoid a potential exploitation. This is what we call, right? So I will just skip this slide. How they are protected internationally. The vulnerable group is internationally protected, mostly by the United Nations Human Rights Monitoring System. So monitoring bodies, Human Rights Committee, Committee for the Elimination of Racial Discrimination, Committee on the Elimination of Discrimination Against Women, Committee on Migrant Workers, and also we can talk about children and refugees and others of the special concern. The section this also include selected cases from ICJ. There are a number of cases referring to protection of vulnerable people, and ICTR, ICTY, and a special court of Sierra Leone. They are talking about in times of armed conflict or in times of crisis or internal disturbance, how the minority group or otherwise a vulnerable group should be protected. Now we are going to talk about some reference from Indian Constitution. Also Article 15.4. Clause 4 of the Article 15 is a fountain head of all provisions regarding compensated discrimination for scheduled caste and scheduled tribes. This clause was added to the First Amendment, as you all know that Champakam, Dorarajan and State of Madras case. In that case was stated that nothing in this article or in Article 29.2 shall prevent the state from making any provision for the advancement of any socially or economically backwards classes of citizens or for scheduled castes or scheduled tribes. This is an open provision, and the judgment is talking about nothing will prevent for treatment of, we call it affirmative action or otherwise. This clause started an era of reservation in India. This goes talking about, in India there are multiple socio-economic disadvantages that members of the particular groups experience, which limits their access to health and healthcare and other services. The task of identifying a vulnerable group is not an easy. That depends on the situation, circumstances, and so on. Besides, there are multiple and complex factors of vulnerability with different layers, and more often than once it cannot be analyzed in isolation. It's connected to most of the factors. Even currently, we can talk about this due to COVID-19 pandemic situation, we became so vulnerable, right? And also you can see there are some other articles, Article 41, 42, 47, directive principles enshrined in the Constitution. And we can discuss this during a question and answer session. And also Article 42 and 47, and go ahead. Now with the South African Constitution. South African Constitution adopted what is believed to be one of the world's most progressive constitutions. The Bill of Rights, Chapter 2 of this constitution provides for the protection of civil, political and socio-economic rights of all South Africa, in all the people in South Africa, including the rights of human dignity, equality, non-racialism and non-sexism, as well as the supremacy of the Constitution. Despite this constitutional protection, the rights of vulnerable and marginalized groups in South Africa are still far from being realized, and the structural violations of their rights persist. Right? The Constitution of South Africa, Section 9, is talking about the Constitution specifically prohibit direct or an indirect discrimination by the state or an individual against anyone on the basis of race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth, and it constitutes a constitutional violation of persons' rights. So this is a very broad section of protecting individuals of a group belong to a vulnerable group. Further, it goes, there are a number of other provisions in the South African Constitution, Article 27, then Article 28, 29, 30, 31, it goes on talking about protection of the identified vulnerable groups from any violations. And also, we can see there are number of laws other than the Constitution in South Africa, very specific provisions are there in order to protect vulnerable groups in South Africa. I don't want to go into one by one, and you can see another older persons, vulnerable children, and so on. Now I'm coming to a Sri Lankan Constitution. The 1978 Constitution of Sri Lanka guarantees equality before the law and equal protection of the law to all citizens, and includes a provision to introduce temporary special measures to achieve substantive equality. So we, in this Constitution, Article 12.1 says is all persons are equal before the law and are entitled to the equal protection of the law. Article 12.2 says, talking about non-discrimination, right? Then Article 12.4, paragraph 4 says, nothing in this article shall prevent special provision being made by law, subordinate legislation, or executive action for the advancement of women and children, and disabled persons. So the Constitution itself, Article 12.4, identify women, children, or disabled persons as a vulnerable group. The group can be protected by bringing a specific articles and a specific provision to protect them that may not be a violation of fundamental rights of this chapter. Then now we can talk about the directive principles of state policy and fundamental duties of the Constitution of Sri Lanka. It's very clearly talking about Article 27 onwards, talking about the directive principles of state policy herein contains shall guide the Parliament, the President, and the Cabinet of Ministers in enactment of laws and the governance of Sri Lanka for the establishment of a just and free society. This is a cornerstone and directive principle for the state when they make policies and legislation or other implementation. Article 27, 1A talking about full realization of fundamental rights and freedoms of all persons of the community, a society of Sri Lanka. B, the promotion of welfare of the people by securing, protecting as effectively as it may, a social order in which justice or social, economic, and political shall guide all the institutions of the national life. Then C, the realization by all citizens of inadequate standard of living for themselves and their families, include adequate food, adequate clothing, adequate housing, and continuous improvement of living conditions and full enjoyment of leisure and social and cultural opportunities. Then it continued to talking about their welfare and equal treatment. Then paragraph E is talking about the equal distribution among all citizens of the material resources of the community and the social product, so best to be the subserve the common good. And last paragraph talking about establishment of just society, social order, and so on. So here, what I wanted to emphasize here, though directive principles of state policy and fundamental duties are stated, but according to the constitutional provision, Article 29, it cannot be justiciable or cannot brought any action for non-implementation of these provisions before the court of law. That is another challenge we feel. But in Sri Lankan jurisdiction, most of the judges, or specifically certain judges, were very curious to use the directive principles of state policy and fundamental duty, this chapter, in order to interpret Article Chapter 3 constitutional fundamental rights provisions of the Constitution. When they interpret fundamental rights provisions, they wanted to use as a shed lights of this provision, ideas from this provision to interpret the fundamental rights provisions. And also, I just want to highlight one point. This is our independent constitution. In that independent constitution, one provision was there. We call it Minority Protection Clause of 1947. In that constitution, a specific minority protection clause was inserted in section 29, wherein the Ceylon Parliament was precluded from making or passing any discriminatory legislation on the basis of race, religion, caste, and etc. This was highly discussed, highly considered provision in that constitution, but in the subsequent constitution of 1972 and 1978, because of very detailed fundamental rights provisions have been proposed, therefore this clause lost its importance in the subsequent constitution. But still, scholars are talking about the worthiness of this sort of a provision in the constitution in order to protect vulnerable national minority. Then we can talk about European courts on vulnerable groups. I have chosen only one case, Chapman case. This case is talking about a very simple issue of this case involved a Roma woman who was evicted from her own land because of she stationed her caravan without a planning permission. The court rejected applicant's alleged violation of the right to respect for her minority lifestyle. It also dismissed her discrimination complaint. On what grounds? This is the argument. The applicant's argument was that the UK government prevented her from pursuing a lifestyle that she viewed as central to her cultural tradition, living and traveling in a caravan. But however, the court's great chamber held vulnerable position of gypsies as a minority means that some special consideration should be given to their needs and their different lifestyle, both in the relevant regulatory planning and framework and in reaching the decision in these sort of a particular cases. This is one of the case, very interesting, how far the European system or European courts, they have gone to interpret the protection and promotion of vulnerable groups' rights. So then now I'm coming to the last segment of my presentation. Now we can talk about emerging challenges. Emerging challenges is mainly my focus on limitations on rights. So almost all the constitutions in the world have very clear fundamental rights chapter, and they have very fabulous provisions, but by clawback clause, by putting limitation clause, all those beautiful rights are suppressed or limited. Limitation on the certain human rights can only be justified under certain conditions established under international human rights law. So therefore, I just want to highlight there is a guidance in the Syracuse principles. It's very established principles of international law. We can take some idea from these principles. This is the restriction is provided for and carried out by in accordance with the law. Number two, restriction is the interest of a legitimate objective of the general interest. The restriction is strictly necessary in a democratic society to achieve the objective. Number four, there are no less intrusive or restrictive means available to reach the same goal. Number five, the restriction is not imposed arbitrarily, that is, in an unreasonable or otherwise discriminatory manner. And finally, the restriction is the time limited and subject to review. So limitations parts of the Constitution is very important. The arbitrary limitations or suppression of human rights is not good for the protection of the vulnerable rights. So this is my conclusion of this presentation. There is an inconsistency and non-compliance with international standards through the constitutions. Then reasoning in terms of vulnerable groups opens a number of possibilities, most notably the opportunity to move closer to a more robust idea of equality. However, the concept is also has to come inherent difficulties. And then characteristics of the vulnerable groups concept, rational, particular, and harm-based. The prejudice and stigmatization or misconception or misrecognition cases are there in the countries, and social disadvantage and material deprivation of maldistribution cases are there. And the effect of the vulnerable groups concept in the court's case of substantive equality should be highlighted through the interpretation of the provisions and protection of vulnerable rights. And margin of appreciation in the European Court ruling is a good example we can take as another yardstick to apply these provisions, constitutional protection of fundamental rights of vulnerable groups. So with this remark, I conclude my presentation. Thank you for giving this opportunity to the I thank to the organizers and our colleagues from the University of Colombo. Thank you.
Thank you, Hakim sir. It was really a treat listening to you rightly and nicely, we can say, talked about vulnerable groups, and you also compared different constitutions, South Africa, and you have given the decisions like European Court's decisions also you have discussed. It was really nice to listen to you, Hakim sir. Thank you very much for joining this webinar. I would like, yeah, thank you, sir. I would like to ask audience if they have any questions to Hakim sir. Please proceed with your questions. Okay, so I guess there are no any raised hands for question answer sessions. So thank you, Hakim sir. So with this, we actually we are over with all the speakers speaking about this comparative constitution approach on fundamental rights, and all of them like Hakim sir and Vasanta ma'am from Colombo University and Jain sir, all were there, and then there were so many question answer sessions in between also, and then there was no need actually in the end, but only for Hakim sir we have like kept this, and then students were waiting also for question answer session. But if there are no questions, then I would like to request our chief coordinator of this webinar, whose restless efforts have made this webinar come true, Sheetal Keskar ma'am. Over to Sheetal Keskar for vote of thanks.
Thank you, ma'am. So good afternoon, one and all. It gives me immense pleasure to present the vote of thanks for today's international webinar on emerging trends of fundamental rights, comparative constitutional perspective, that was organized in collaboration with Department of Public and International Law, Faculty of Law, University of Colombo. So first of all, I would like to thank Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka for accepting our invitation and for collaborating with us. Today for this webinar, we had eminent personalities with us, having specialization and who have contributed in this particular field. So we had with us Mrs. Vasanta Senivaratne ma'am. She is head of the Department of Department of Public and International Law, Department of Public and International Affairs, and also researcher on minorities, Faculty of Law, University of Colombo, Sri Lanka. Then we had with us Mr. M.A.M. Hakim sir. He is a senior lecturer at the Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka. Then we had with us Mr. Avinash Kule sir. He's retired associate professor and also a novelist, bilingual columnist of national as well as international affairs, and also researcher on minorities. We had with us Professor Dr. Sanjay Jain sir. He's additional charge principal at Indian Law Society's Law College at Pune. So I would like to thank all the dignitaries for sparing their time with us and enlightening us with their knowledge. I would like to thank Dr. Gajanan Egbote sir, Chairman of Business Council at Peace Society Pune, for the motivation to organize such seminars and conferences in our institute. I would like to thank Advocate Dr. Chintamani Ghate sir, coordinator, PS Modern Law College, and Dr. Sunita Adhav ma'am, principal at PS Modern Law College, for making this event possible and their continuous support. I would like to thank organizing committee, including teaching and non-teaching staff, for their unflinching support and coordination. And last but not the least, our heartfelt thanks to all the participants for their active participation in this particular webinar. So with these words, we move to the end of the seminar. Thank you so much.